Good afternoon. Welcome. This is the time and place for the June 15th, 2016 Planning Commission meeting. May I have a roll call, please?
Planning Commissioners Astorian.
Here.
Landrigan.
Here.
Lee. Manukian.
Here.
Shahbazian.
Here.
If we would all rise for to Pledge of Allegiance, which Mr. Astorian will lead us in.
Please follow me in the Pledge of Allegiance to the flag of this greatest country on the face of the earth. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation under God, indivisible, with liberty and justice for all.
I like that.
All right. Thank you. I'm going to give you the report of the posting of our agenda. The agenda for this meeting was posted on Wednesday, June 8th, on the bulletin board outside City Hall and the city's website. Do I have approval of the minutes?
I have to abstain. I was not here, Madam Chair.
Yes, ma'am.
All right. Commissioner Shahbazian, Mr. Manukian? All right.
Yes.
Approved. Thank you. I don't think I have any oral communications.
Yeah.
I think everybody is here to speak on an agenda item. Is there anybody who does have an oral communication? Seeing none.
Madam Chair, some lady by the name of Miss Rola, she said she wanted to speak under oral communications.
Okay. Do I have a card for her?
Yes.
That's the one that.
Miss Rola.
All right. If you want to, if you're speaking on something that's not on the agenda, that's what an oral communication is. You're speaking on something on our agenda? All right. So that's not oral communication. So you want to wait until the agenda item is called?
Yes.
All right. Thank you very much. Okay. So just want to make sure. All right.
Oh, boy.
So there are no oral communications. Zoning appeals, new business, there are none. Item 1, old business. Appeal of Deputy Director's decision for noise code violation, case number N-Noise 1305975. May I have a planning presentation?
Thank you, Madam Chair, members of the Commission. My name is Renee Sada, the Co-Compliance Inspector assigned to this case. This matter involves a request to reverse an exemption granted from the noise ordinance in regards to 3 air conditioner condensing units located at 1349 Imperial Drive, which is a single-family residence located in the R1R residential zone. The appellant resides at the neighboring property located at 1341 Torres Drive, a single-family home in the R1R residential zone. In response to a complaint filed by the appellant, it was found that the air conditioner condensing unit's noise levels were in violation of the noise ordinance code standards. After receiving a request for the exemption from the applicant, Deputy Director Tim Foy granted the exemption on July 10, 2014, based on the findings that there were no additional reasonable or feasible measures the owners could take to reduce the sound levels of the air conditioner condensing units. The air conditioner condensing units were installed under permit in 2003 and are located in the interior setback area on the northwest side of 1348 Imperial Drive. After the owners were notified of the violation, they took the following actions, attempting to lower the noise levels of the 3 air conditioner condensing units. 1, planting ficus trees along the northwest property line. 2, installing sound baffling barriers around the air conditioner units. 3, installing sound-suppressing blankets around the air conditioner units. Staff is recommending that the decision of Deputy Director Tim Foy be upheld and the appeal denied, and staff is available to answer any questions the members of the Commission may have.
All right. I am going to open the public hearing here, and I'm going to read this information. This item is an appeal from a decision under the authority of the Director of Community Development. This matter is heard as a de novo hearing. Decisions rendered today will be based on the evidence presented at this hearing and in the file. Individuals speaking today should present all the evidence which they may wish this commission to consider. Appeal items are considered as public hearings. The commission will consider testimony from the applicant, the appellant, the applicant, staff, and any member of the public willing to speak. If you wish to speak, you have to fill out one of our cards and present it to the secretary over here. Thank you very much for your presentation. Are there any questions from the commissioners to the staff? All right. So I would like to call up the appellant to do their presentation. I only have one card here, and that is Andre Kronthal. Okay, so I don't have a card for the appellant. Are you the appellant?
Yes.
Would you like to come forward and then fill out a form for me afterwards?
Thank you.
Thank you.
If you remember 1 month ago,
He isn't the appellant.
Oh, I'm sorry.
You're not the appellant?
It's Lena Ramstoff.
Lena Ramsoff is my mother, and I'm representing her.
That's fine.
That's fine.
Thank you.
Okay.
1 month ago, we came in front of your
But
panel.
you need to give us did you give me your name?
Yeah, Alex Ramsoff.
Thank you.
1 month ago, we came in front of the panel and we requested a continuance because our expert, in which this is a technical issue, was held up in San Diego. The expert is here now. His name is Aaron Petit, and he represents Ascentech. Ascentech Incorporated did the first initial acoustical engineering report for us after we were denied an appeal for the first exemption. We were unallowed to rebut the applicant's request for exemption, did not have the chance to be heard, and the exemption was granted. We requested an appeals, and the appeals we weren't given the appeals. In a sense, the city told us that this was a final decision. We knew that there were mistakes done in the exemption. Specifically, the city failed to do certain noise tests. And the result of that was one of the bases for the first exemption. That is that the first exemption states that the indoor noise violation is less than 2 decibels. The city failed to take an ambient test, and we hired an acoustical engineering firm to do the ambient test, which found out that the indoor violations were gross, and to retest the city's testing outdoors and the offensive noise indoors. We submitted that information to the city attorney and to the city manager, and we were promised that it would be looked at, and we were expecting the exemption to be overturned so that we would have had a chance to counter the applicant's evidence. We never received any of our document information requests, and we were essentially left in limbo for about 6 months. We asked for an update, and we're told that the city has made a decision to go back to the applicant and request additional evidence. We objected, but they gave the applicant a 60-day extension in which he hired a consultant, an architect actually, interestingly enough, to come up with a report. And
I do need to tell you, Mr.
Ramsoff, yes.
Ramsoff, that you have 15 minutes along with your expert to present
Okay.
this total.
Okay. There's 2 points where there's some confusion. The applicant, after the first exemption, has actually submitted 2 reports. The city has only presented one of the reports in the evidence. The exemption, the second exemption, refers to a July 17th report, which I don't believe you have. And our expert is here to testify on the July 17th report. Now, the July 17th report formed the basis for the second exemption. The first the first report submitted by the applicant after the city went and requested additional evidence was actually rejected by the city attorney's office and sent back to the applicant for additional information. And I'm not clear on why that report is not included in it. Now, we called the Community Development Department to ask for that, and we weren't really given a response. The report that is in your evidence package, as I mentioned, was rejected by the city attorney's office as insufficient. I do have an email showing that.
Do you have the exhibit that you provided to us? Is that included in there, sir?
We have not provided any exhibits to you, Ms. Lannigan. We have failed miserably. I was not about to ask for another extension because of that. So I'm doing it off the cuff.
Okay. Whatever you do give to us then becomes part of the public record. We keep it.
I understand.
Okay.
I understand. I can give you anything that I have. But what I'd like to share with you is this email from the Assistant City Attorney. I just have one copy, and we have
Please hand it to Mr. Historian, Commissioner Historian.
And that's the email that rejects the first finding of facts by Mr. Nardella that you have in your evidence.
Thank you.
I can make copies. I can just make copies.
The other missing information in your package is the applicant's actual request for exemption. We're not sure why that wasn't included as well. The reason why that's a contention is because that email no longer exists on the city servers, and we believe that the hard copy itself has been destroyed as well.
What are you referring to, sir? Which one?
The applicant has his request for exemption was an email to the code compliance inspector.
Do you have a copy of that?
Yes, I do.
Do you want that to be part of the...
That's fine. That's fine.
Let me have that so we can have copies of that, too. And what you're claiming is that does not exist on the server or any hard copies of it? Is that what you're saying?
We made 4 requests to the city attorney's office, and we're told that it has been deleted and purged.
Okay. You also referenced the July 17th report. Who was that by?
That was the applicant's expert.
Do you have a
copy of it?
of that? Why don't we have that?
Good. We don't have it.
July 17th.
Get the table contents.
Shanaz, to make copies of these 5 at least, so we, after this unique
This one or
No, there's another one.
there is one more. There's a report that there.
July 17th.
This is, and it's, okay, you can sit down, sir. This is prepared by an attorney.
No, it's an architect, actually. It's
okay.
for the applicant who is an attorney.
Okay, is it Ramsoff now?
Ramsoff is fine.
All right. I'm having to write it because you didn't write it, so
I
forgive
appreciate
me.
it. Thank you.
Is there further presentation you want us to consider at this time?
I would like to present an argument on the setback. The code compliance inspector, in his opening, said that the air conditioning equipment is permitted and that it is within the zoning ordinances for its location. I disagree. The air conditioning equipment is approximately 5 feet from the property line, which is within 10 feet of the setback. The present code has an exception to mechanical equipment on a side yard or an inside setback that allows for the equipment to reside in the setback. We're not sure if that exception existed in 2003. If you look at the code, it shows that it was enacted in 2004, and we're unclear whether there was an exception prior to 2004. The 2004 exception states that the mechanical equipment needs to be enclosed. The Community Development Department has a link on the website that shows the type of enclosure that needs to be done, and I verified with the city planners. This is what we were hoping for.
I don't think I need you giving me the code. I can ask the staff.
And we do need you to speak into the mic because we record.
This is the enclosure that's shown on the city's website, and I don't know if you've seen that or are aware of it, but if I could present this to you, then if not, I could give you the link.
Thank you.
We also have a photograph of the applicant's equipment that shows that it doesn't follow the residential equipment enclosure recommendation.
We have photographs. Thank you.
And I do have one last concern in regards to this. The city took 3 noise tests. Found the applicant in violation all 3 times. The applicant did some minor attenuation measures. After the 3rd test, was found in violation again. We have an email which shows that he requested the code compliance inspector for some suggestions. The code compliance inspector did provide a suggestion for a 3-sided wood panel with acoustical blankets inside. The applicant responded that, yes, that's exactly what he needs, and he'll have his contractor do it. He failed to do that. The applicant's submission in regards to his request for exemption is that there are no other measures that can be taken at this point. We strongly disagree, and unfortunately I do not have the exhibits or the time to present that. The applicant's panels, and our expert will explain, are actually not acoustical panels. They're not lab certified, and we have a copy of the patent that shows that the patent is actually for an ornamental folding fence. I don't know if you need a copy of that patent, but the assertions have been made throughout with his consultant that these are somehow patented acoustical panels. They are not lab certified, and there are no patents that are based on acoustics.
Now, in the remainder of the time, do you have something you want your expert to present?
Yes. And our contention is that the applicant has not met his burden of proof of technical infeasibility.
All right. You have.
Should we
let's
wait?
wait, and we'll ask them both questions.
Thank you.
Sir, I don't know how many minutes you have, but it's short.
Yes. Actually, I will be short.
Thank you.
My paper.
Thank you.
Sure.
And Mr. Ramsoff, please fill out one of these for me.
This is this.
It's the same.
Oh, July. Okay.
Okay.
Hi, my name is Aaron Vitti. I work with a company called Ascentech. I appreciate the time to talk about this exemption. I wrote a detailed letter that I think is better than me spending all this time to talking about it. I'd rather talk a little bit about
Please
the overall.
give it to the secretary, and she will make copies for us. And in
Can
the
I ask a
future,
question?
you
Why
need
is
to
it-
prepare. In the future, you need to prepare this material ahead of time.
I
The
thought
hearing
that
is
yeah, agreed.
that we are supposed to be able to read this material ahead of time.
Agreed.
and not during the meeting. It's really disrespectful to the remainder of the individuals who come here to prepared and to assume that we have read this to carry on a discussion.
I completely apologize, and I agree. And my intention, I had thought that letter had been submitted. I'm sorry.
So please present what you have in there, because we will not have time to read it.
Okay, let me present the overall, and then we'll talk about that. All right, so first off, I wanted to talk about what this exemption is. From my understanding of it, my understanding is the exemption says that if it is technically infeasible to comply with the noise ordinance, then an exemption can be granted. And the burden of proof is on the person applying for the exemption. The equipment we're talking about here is air conditioning equipment. This is common, I would think, to the majority of every residential property in the city of Glendale. In fact, the whole Southern California. But so it's not abnormal equipment, and while it is typical equipment to be used, every single home probably operates air conditioning on a regular basis. And so to say that it's technically infeasible for something so common on a residential property to comply with a residential code would require a very detailed study, I would think, that says, we've done all these things physically, we've calculated this, and physically this is the calculations, these are the levels, this is our result, and unfortunately, because of physical limitations, because of code requirements, because of all of these other aspects, we are not able to achieve this. That's the way I would think that this exemption would be permitted. The weird thing about this case is, from all the documentation I've read, I am the only person that has worked in the acoustic design, mitigation, planning environment. I'm the only person who spent 4 years as an engineer with an emphasis in acoustics that's involved in evaluating any of this. I haven't seen any documentation of any single other person who can claim to have spent any time studying acoustics. In fact, the other letters you read on the other side discussing my letters are from an architect who provides his resume, and in his resume has a 2-page list of his expertise and doesn't even indicate acoustics in that expertise. And the company he works for's website does the same thing. The reason why that's important on my side is because there's all these little pieces, like, discussed in these reports that are nuances and there's misunderstandings of quotes, because I'm a technical expert. I've been doing this for quite some time. And if there was somebody on the other side we could talk in this jargon, and they would clearly explain it to the other side, and we'd be able to talk. Things like FICA trees are not acoustics. They shouldn't be listed as an acoustic mitigation in anything. In fact, Caltrans specifically states that in one of my reports. I indicate and reference this. But Caltrans states that in their documentation. Vegetation is not an acoustic thing. And so from the start, the very first list of the acoustic mitigation implemented is not an acoustic implementation as recognized by the state of California. It makes it a little bit complicated for me as an acoustic consultant to kind of convey, look, here are the facts, when the facts aren't quite right on the other side. The report does that. The rebuttal report to my suggested mitigation evaluation does talk about cost. It says, here's some mitigations and here are the costs. Now, in my mind, that says, in order to cost something, you have to actually think about, okay, we can physically do this. The exemption says technically infeasible. If you can cost something, how is it technically infeasible to implement? Granted, acoustics is costly. When I walk onto a job, the architect or the engineer doesn't really want to see me because I'm adding cost to that project, and sometimes they don't see the value. Who sees the value is the community. The community sees the value because, okay, we're putting a power plant in the middle of a residential community, but it has to comply with the codes. I cost them millions of dollars trying to get those property line noise ordinances in compliance, and the community sees the benefit. The person operating that equipment does not see the benefit. They see the cost. When they argue the cost, the thing that's not really evaluated is the cost implications to the property being impacted. There is a cost implication to changing the noise ordinance from a single-family home in a quiet part of the residence of Glendale and saying, you know what, a commercial noise level is more appropriate for this property line. When you change that, you're saying, here's my single-family home, but the noise levels are actually going to be in the range that the city has decided is appropriate for commercial. that seems like there's going to be a cost. I'm not a cost person, but I do know, because I do technical reports when they're changing zoning things. I do issue reports that say, here's the implications to allow people to evaluate whether the project is appropriate. Shoot, I lost my train of thought. Sorry. But the gist of this is the burden of proof that it is technically infeasible is on the person who should have been given the exemption. It's not my burden of proof to prove that it is technically infeasible, but I feel that I have, from the evaluations that I could, from the presentations of the fact that there are so many other residences with the exact same condition. But when I'm saying condition, I'm not saying the equipment or the exact same operating conditions. They cool their houses. They find a way to cool their houses and comply with the municipal code. And consequently, a detailed study saying the reason why this particular residence can't do that, I would think, would be required before an exemption would be granted. All the other detailed kind of things I do go into. My first report is probably the more important one. It talks about actual things. And if you have any acoustic questions for me, feel free to ask. I appreciate your time, and thank you very much.
Thank you, sir. Actually, Mr. Ramsoff and Mr. Petit, I think the commissioners might have a couple of questions for you. And I do... Is that correct, Mr. Astorian?
Yes.
Commissioner Astorian?
I've got a couple of questions. Mr. Ramsoff, you mentioned a document information request that was never received. What is that? What is it, and who is supposed to receive it?
We sent...
And who's
gentlemen.
supposed to give it?
The documents that we requested were the applicant's original request for exemption and any evidence that he had submitted prior to the first exemption. We were denied. We were ignored, actually. We sent emails to the Assistant City Attorney of Code Enforcement, and we also sent it to the Deputy Director, Timothy Foy. We have these emails. There have been no responses. We found out about the request for exemption by accident when we asked for an update after the applicant had failed the 5th noise test.
And this is the letter dated Thursday, May 22nd? Is that what you're referring to?
That is the applicant's letter requesting an exemption.
But you already have, you gave it to me.
We received that 1 year after the exemption was granted.
Okay.
A very quick chronology. There were
just answer questions. Thank you. So we have the applicant's request for exemption.
Which we received 1 year after the exemption was
we
granted.
have it.
Yes, you do.
Okay. We just got your July 17th report as well.
That's not our report.
That's not theirs.
That the
applicant's report.
Applicant's report. Okay. Okay, that'll do. Thank you. I have questions for the staff.
I have one question, actually.
Mr. Ramsoff and Mr. Bettit.
I was just wondering, how was it determined that the acoustic panels weren't according to code?
Please use the microphone.
Let me answer.
Yes.
There's not a code for acoustic panels. When you have an acoustic panel, they have acoustic tests. I called the company up. The company said they've never done acoustic tests on these products.
Okay. So the panels are not acoustic panels? Is that what
I don't think that's the argument is that there's been no acoustic design to the mitigation. No evaluation. There's no technical expert on the other side to talk about any of this. So I don't, it's for someone to come onto the job and just say, "Oh, I put a foam on the wall."
I guess just the question is, the panels that are currently being used, are they acoustic panels?
I have no idea. The company says that they don't have acoustic tests indicating that they work acoustically. They don't have absorptive tests, and they don't have transmission loss tests that say that they operate as an acoustic panel.
Okay, thank you.
Any other questions from commissioners? Mr. Manukian?
Yes, actually, I have a question.
All right.
At the end of the day, what is it that you want the Kronthals to do?
I would like them to do a reasoned analysis of existing mitigation measures, noise mitigation measures, so that we could put an end to the noise pollution that is affecting not only the outside of our house, but the inside of our house.
Okay. as a follow-up. Other than taking these condensers up, moving them somewhere else, which is an obvious solution, right?
Putting distance between the receiver and the source.
Other than that, do you have a solution? In other words, you just told us that there are these blankets that have not been sound tested, certified, et cetera, et cetera. Now, are you aware of some technology, some barrier, something?
Sure. There are acoustic walls that'll stop the sound. The way that, in addition to these existing barriers not necessarily being acoustic tested, and it's hard for me to evaluate because I'm not on the property, but they also stop right at the top of the condensing unit.
Sure.
It's clearly documented in the Glendale noise plan that walls have to block line of sight. I mean, we all know that block line of sight is necessary in order to stop sound. So putting a wall along the property that's absorptive on one side so you don't create a canyon effect where the sound bounces back and forth and just goes over the top, and blocking the line of sight between the master bedroom window and these would reduce it by at least 5 dB, and depending on how high the code allows, it could reduce it 10, 15 dB, which is significant.
Which is significant. Okay, now, so now we know what you want. We have a proposed means of doing this. Have you, gentlemen, done any sort of costing? You referenced.
I'm certainly not a cost expert. I just do acoustics. I'm an acoustic.
You just cost money. You don't.
It's the fun part of my job.
Mr. Mnuchin, if I could just add, there are two ways that one can get a pass on the Glendale noise ordinance. The first one is an exemption, which we feel is a very exceptional way of doing it. It doesn't have any safeguards. It doesn't go in front of the panel. It's done by a middle management administrative staff member, and it doesn't require a formal hearing. Parties that are affected by the noise, I'm sure in a normal situation would have had the chance to rebut. We did not. And if you look at the construction of Section K of 36.290, it states technical and feasibility 3 times. It says it's the feasibility shall be technical. The burden of proof is on the individual asking for the exemption. It is a very narrow construct, and I believe it forecloses any consideration of economics or hardship or any other feasible measures. The second way that one can get a pass on the Glendale noise ordinance is through a variance, and the safeguard is the panel, in which there is a formal hearing and interested parties are allowed to present their rebuttal. We were never accorded that. 2 exemptions. No, this is the first time we've had the chance to actually rebut, and it's been 2 years. I don't believe that Section 8.36.290K is the proper administrative process for this problem.
Mr. Ramsoff, Mr. Bettit proposed a wall. There are other proposals within here that the applicant had put forward. We're going to hear them. We may call you back after that, but they have a chance to do their presentation and for us to have that consideration, and thank you all very much, unless I have other questions from the commissioners.
Not yet.
All right, thank you. Andre Kronthal, who is the owner and the applicant of the original appealed exemption. Thank you, sir.
Thank you very much.
If you could give us your name.
I appreciate the opportunity to speak before you. This matter has been going on for approximately 13 years, as you may be aware.
Sir,
I was struck,
would you
though.
please introduce yourself?
Oh, yes, I submitted a card, but my name is Andre Kronthal.
Yes.
And I'm the owner of the property with my wife of the property at 1348 Imperial Drive. I was struck by the presentation by both speakers because it totally avoided what is supposed to be the main issue of this proceeding, which is whether there is technical infeasibility and therefore no entitlement to an exemption under the ordinance that we're talking about, which is 836290K. That is the purpose of this. That section is very specific in defining what technical infeasibility is, and that was totally ignored by both speakers. It requires that it shall mean limitations cannot be complied with despite the use of mufflers, shields, sound barriers, or any other noise reduction device or technique during the operation of the equipment. During the operation of the equipment, Mr. Bennett didn't mention that in his actual report that we received a long time ago, one of his first suggestions was to turn the equipment off. That's entirely inconsistent with a feasibility measure that works or doesn't work while the equipment is in operation. Mr. Bennett admitted that he is not a cost expert, and the panel properly questioned him about the costs of the alternatives. The report that we've received from the other side, in fact, every document we've received from the appellant, does not take one effort to estimate what the costs would be of these alternate methods. The alternate methods that they propose, and I don't know whether one was just presented that I've never seen for the first time today, if it mentions costs or not, because I haven't had an opportunity to look at it. And as a side note on that, to the extent that I haven't had an opportunity to review any of this material, if the Commission is at all considering reversing the proper decision below, I'd want an opportunity to be able to address it, because as the applicant, the person accused, I have the burden of proof, and therefore I should have the right to have the last word, as every single accused has in every court in this country. Getting back to the point of costs, they don't mention what these things will cost, and they don't address what technically feasible measures using mufflers, shields, sound barriers, or other noise reduction techniques of that type would be. They suggest the wall, which has to go entirely along the length of a lengthy property line, but they don't state how much that wall would cost. Mr. Bennett just mentioned, acoustic wall is the way to go. No specific type of acoustic wall is specified in his report, and he is supposed to be the expert. Concerning the other item, turning the equipment off, that's totally inconsistent with the plain language of the code itself, which refers to the equipment being in operation. The third option, moving the equipment to some other place in the property, well, there's no showing that moving the equipment would be feasible at all. Fortunately, we submitted reports from an architect, and now you have both of them in the file, so I'm not submitting any new information to you at all. It's already in the file and has been considered. The reports by Mr. Nardella, the architect, addressed specifically whether it would be feasible to build a wall, to move the units, or to turn them off. Obviously, turning them off is not an option. In terms of moving the units, the property, it doesn't work that they would go in the front or the back, and I understand it from Mr. Nardella that putting such units on the front lawn of the property or the back yard of the property is not even permitted by the city and not practical. And there's been no showing about how putting them on the other side, that would be the east side of the property, would be at all practical. There's no space to do it. And the terrain of the land is such that it wouldn't be feasible. The cost, even if it could be done, as Mr. Nardella points out, would be in the $16,000 to $26,000 range, because you'd need to move the existing equipment, you'd need to reroute the interior equipment, and do work on the interior. So with contingencies, it could cost in excess or up to or in excess of $26,000 for that. The wall would cost somewhere between $19,000 and $38,000, according to Mr. Nardella. These are not practical measures, nor do they prove that they would be effective in bringing the noise level down to a level that would be acceptable. Let's put this in perspective. The finding of sound was 60 decibels, 5 over the limit. It was at 69 before. The sound measures that were implemented, the blankets inserted into the units, the barrier around it, the ficus trees, all of that stuff managed to reduce the decibel level from 69 to 60. We've mentioned that typical units, typical AC units, even if they're high efficiency, are in the 73 to 78 decibel range. And I've got an article by an acoustical expert here for backup, but I mention it in the materials submitted in the file. So if a normal high efficiency one unit is in the 73 to 78 range, then how is it that we could ever improve with any units on a 60 decibel improvement level that we've already reached? It's no surprise that an HVAC contractor supplied us with a document that you should have, but I have it here in case you want to look at it, saying that the condensers are of good quality and relatively quiet compared to other units in the marketplace. The sound suppression blankets installed in the units keep the sound to a minimum level, and there are no other devices available to reduce the sound further. He then goes on to state that replacing these units with newer units would cost $22,800 plus tax and installation. So, and that's attested to by JC's HVAC Mechanical Company, and that was dated July 22, 2015. And I've got extra copies here of that. So imagine that with 3 units, not always running at the same time, it's a multi-level structure, and that's why there are 3 units. And they can run at different times as needed for efficiency. 3 units emitting 60 decibels versus a high efficiency unit maybe emitting 73 to 78 or more. These are efficient units. If these units are in violation and if their appeal has any merit, then every owner of an air conditioning unit in Glendale is subject to this offense and subject to being banned from using their units. But in this case, we've demonstrated that we've taken the reasonable, feasible measures to minimize that noise, and it isn't that far above the required level. Those issues have been ignored by the other side. They haven't addressed the technical infeasibility. Relying on it, I didn't understand why Mr. Ramstoff mentioned a document that was submitted that was never provided to him a year ago, but then he says he's had it for about a year. So I'm not. If that's the kind of argument that they're reduced to making, that an option is to turn the machines off, and that this is unfair because we weren't provided with a document until about a year ago, then I think it shows the lack of merit in their appeal. I think I just have a couple of more points, if I may. How many minutes do I have left?
All I know is you have the green light, and you got to go until you have the yellow light.
Thank you very much. Quiet fence. It was brought up that there's some issue with this quiet fence. I actually spoke with the owner of Quiet Fence, Rue Deal, D-I-E-H-L, the owner and patent holder for Quiet Fence. I have my contemporaneous notes of my discussion with Mr. Deal, which occurred in June of last year, 2015. Quote, he told me that a linear measure, the reason for this call, let me digress, is that Mr. Bennett was arguing that you need to have 2 pounds per square foot density in the fence in order for it to be functionally able to work. Mr. Deal explained to me, first of all, he was shocked that an acoustical engineer would talk about a linear measure. He said using a linear measure for a sound barrier makes no sense. The consultant claims that the barriers, the consultant being Mr. Bennett, need to be 2 pounds per square foot in density, but this is meaningless because density is measured in terms of thickness as well. It's not just square, it's cube. Concerning this density, it so happens that the Quiet Fence is a high-density polyethylene HDP, which is rated at 0.035 pounds per cubic inch. Now, 2 pounds per cubic foot would be 0.001157. So if we were using 2 pounds per cubic foot of density, then the fence that I have, the quiet fence, is actually 20 times more dense than what Mr. Bettit has said is necessary for such a fence. And he admits in his report that he didn't really get a chance to examine the fence up close. So Mr. Deal provided some other details, the ASTM, the hardness, the specific gravity of the fence. It has the patent information right on the product itself. So this new assertion that was never stated in their previously submitted report, so this is sandbagging, that there's some issue with a patent or something that Mr. Deal said that somehow helps them, is sandbagging of the worst type, because we've had years to go over this material and to get it right and to get it before you before this afternoon. I think I'd just like to sum up, because there's a reason your code 836-290K is written as it is. It is very specific, and it mentions mufflers, sound barriers, because that's what the law was intended to require an owner to put in, or to show that it wouldn't help in order to get an exemption. It doesn't say anything about walls. It doesn't say anything about turning equipment off. It talks about operating the equipment, and it doesn't say anything about moving the equipment to another location. It says what it says, and it's the law that we were all bound to follow. In reliance on that law, that's what we focused our documentation and presentation on. Were the sound barriers and noise mufflers that we used sufficient? Accordingly, they weren't. The noise was still a little bit higher than required under the code. But was there a measure other than that we could use? I mean, no. Was there a sound barrier or a muffler that we could use? No, we already used them. We already used them. We've met the standard because we've used everything that the code says we should try before you can consider an exemption. Unless you have any questions, I'd submit on that.
Commissioners, any questions for Mr. Kronthal?
I do. The report that presumably you don't have, is that the Centec report dated May 16, 2016? Is that the one?
I've never seen it.
So this is the one that you don't have. Right now it is public, it's part of public documentation. So you're more than welcome to read it as well.
Very good. I hope to have that.
I have a spare copy here, sir.
Would you like me to read it now and comment on it? If I...
No,
really.
That's all right.
Okay.
But
I mean, the fact that
I think you should have anything that was here should have been given to you. So.
Well, again, the fact that they had a month before this hearing to provide it to me, and they didn't do so, and again, trying to sandbag here at the last minute with this stuff, shows the lack of merit and their lack of faith in their own case. And if this carries any weight at all with the Commission, I would ask for an opportunity to address it formally.
Let me, Mr. Storian, do you have any questions?
No, I do have a bunch of questions from staff, though.
Okay. Any other questions from the commissioners? Thank you, Mr. Kronthal.
Thank you very much.
We do have time for the appellate to rebut. And I think that's a 5-minute rebuttal.
Very quickly, we had quite a bit of information that we wanted to submit. Unfortunately, we had a death in the family, and that's taken us completely off the case, and our life has been in disarray for some time, a couple of weeks at least.
My condolences.
Thank you. He was a good man. He was a former federal judge. I provided a
Mr.
summary.
Ramshoff, please use
I'm sorry.
Thank you.
This is a summary of the noise tests, and what this will show that the applicant is still in violation, and this is the city's test, of 2.6 times greater than what the city allows. Mr. Kronthal, the applicant, has misstated the Glendale noise ordinance, in which he mentioned that it's the presumed noise levels is what he meant by his offensive noise levels being slightly higher. The Glendale noise ordinance states that you should use the ambient or the presumed, whichever is lower, and I think you know that. So, in fact, that his violation is quite a bit greater. And if I could give you the summary, or if you care to see it. No, okay. The applicant has misrepresented what our acoustical engineer has said about quiet fence. What I do have is the actual copy of the patent. I don't know if the panel needs to see that, but it clearly is not an acoustical patent. You need to see
Do the
that.
commissioners
You need to see the
want
patent.
a copy of it?
If it was not an acoustical panel, how would it drop the dBA from 69 to 60?
It's a very good question, sir, and it did not. The only thing that did drop the dBA was a sound blanket, and it had a very minimal effect of 6 dBA, which is significant if it wasn't such a large violation. There is no attenuation measures that the applicant has performed other than the sound blanket, which is a very common attenuation measure. The ficus trees, the panels, all have had no acoustical.
So that's 6 dB. Where's the accounting for the rest of the 3? It's 69 to 60, not 69 to 63.
It's not. It's 69 to 62.
This would be helpful if you'd like to take a look at it.
He's got it, right?
No, that's
He's read it.
It's in the.
It's in the last
Yeah,
section.
I just summarized
It's in
it.
Tim's letter.
The concern that we have as well is that the code compliance inspector used 2 different meters during the testing procedure. That's not disclosed in your packet. The first 3 tests were done with a meter in which the applicant impeached. There was a concern that it didn't actually provide weighted averages, and so the city acquired a new meter. Performed a 4th test, which was inconclusive. Performed a 5th test, which found him in grosser violation. It's technical, and I don't have the time to do it. So we actually only have 1 point of reference for the applicant. So anything in regards to how many dBAs were reduced and so on, I don't believe are applicable. But we're at a crossroads, I think, where the applicant's clearly in violation, and we feel the applicant has done virtually nothing. The panels cost approximately $140. The blankets cost approximately $60. We've spent, without our experts witness, we spent more on the fee to be here than the applicant has done in 13 years. There's an email that, and once again, my failure, that states to the code compliance inspector that he would have done nothing. But because of this, he has done something. I have photographs of a representation of what the code compliance inspector had recommended. The applicant has failed to do that. He took the easy way out. He bought mail order off-the-shelf panels and called it good.
Can I ask a question? Mr. Ramsov?
Oh, I'm so sorry.
Now, don't take this the wrong way, but did you guys ever change the windows from which the noise travels into your property?
Yeah,
or your mother's home?
No, it's a very good question. It has been brought up. The windows have been changed, and they were changed approximately 2 years after the machines were installed. The way the house is designed, it's a rancher, and the bedroom window is the window that goes on, above the bed, so that provides the cross ventilation. We're not dealing with just one condenser unit. We're dealing with 3, and they cycle on and off, and you have these screeching, grinding noises as they cycle on and off. My mother has had to move out of the master bedroom because she prefers to have the windows open. We live in a very quiet neighborhood. The ambient is actually, the city of Glendale has a noise element in which there's a technical appendix. The ambient that was tested by our expert shows that we are even quieter than the quietest neighborhood in the technical appendix. We're in the 30s.
Okay.
Any other questions for the appellant? You have maybe 1
All right,
minute.
I just wanted to
Why?
say that some of this information that was presented is what I was talking about, where it's a misunderstanding of people talking. Now, the first part is density versus surface density. In my report, I talk about surface density. I don't talk about density. That is not what I'm saying. And so surface density is a common terminology that structural engineers and acoustic engineers use to talk about things. The other part is
You have a very short time
sound
to
barriers versus
summarize,
walls.
please.
A wall and a sound barrier are the exact same thing. What I'm talking, and he's saying that and Section K says despite the use of sound barriers. There is no proof that they've put in a sound barrier. A sound barrier has to block line of sight. It doesn't block the line of sight. Therefore, they have not put in a sound barrier. And a sound barrier and a wall are the exact same thing in the terms of acoustics. Thank you very much.
Thank you,
I have
Mr.
a question
Bennett.
from you, sir.
Yes.
Okay. Thank you.
How tall does the sound barrier have to be in order for it to actually
So
function?
it's a calculation thing, right? So I would have to look at where the receiver is, where the source is, and then how much attenuation I'm looking at, and the distance between those things.
Okay.
If you block line of sight, rule of thumb is you get 5 dB. If you want more than that, you have to start putting the wall up higher. That's kind of a general summary.
So, and my understanding is that our code allows 6-foot tall wall. Is that correct? So they might have to actually go through a variance process.
No, because the way this property is set, the offset is so much that a 6-foot wall would pretty much block over the entire roof type of thing. So it wouldn't have a problem.
Any other questions?
And
All
that
right.
would be about 20, maybe 15.
All right, I am closing the public hearing. I'm sorry, sir, there is no rebuttal on your part. Commissioners, do you have questions for staff?
Yes, I do. And I don't know who's going to be answering this, but what's the exception, the 5 feet exception that the gentleman just spoke about that was not in our code in 2003? The setback it's located at?
The zoning code has a setback exception to allow mechanical equipment within the setback area in the interior, provided that it's screened. I don't know. I don't think that it wasn't there in 2003, but I don't really have that information right now. But the original permit was from 2003, and then essentially he said the site in the code was changed in 2004. I don't think that was one of the changes, but I don't know that for certain.
So the next question, Mr. Cross, is if the code requires specific items as mitigation measures for reducing sound, such as mufflers and sound barriers, or is it in general, for example, would an acoustic wall be considered a sound barrier?
I think anything that falls within what the code would allow in terms of setback provisions and everything else could be used as a sound barrier. There's nothing in our code that says this use could be used for that to deaden sound. We don't have that kind of information in the code. But whatever they decide to put up or use in order to create that barrier would have to meet the zoning code.
Okay, so it's not only two specific things, that it's mufflers and sound barriers. The interpretation of what a sound barrier is left to...
Essentially, whatever would deaden the sound would be considered a sound barrier.
Okay. Thank you.
Other questions for staff? Commissioner Manukian? Commissioner Shabazian? I actually do. And I don't know about this, but I know that if you get a fence permit, you have to have agreement with your neighbor. You have to. You all require individuals speaking with whoever you're putting the fence in with. When you do an exception to a noise ordinance to an adjacent neighbor, is there no requirement to be in consultation with an affected neighbor?
There's, Madam Chair, members of the Commission, there's nothing in the noise ordinance that basically states anything about noticing or anything else. It doesn't really, it's kind of really, the noise ordinance allows you to apply for an exception under the noise ordinance code. So once it's not under Title 30. Had there been something that was under Title 30, then it would require noticing.
Okay. Thank you.
You're welcome.
Commissioners? Discussion? May I ask our legal, Ms. Nukian, if we move to reverse the deputy director's decision, what does that then require the individual who had received it to do? And what would their option be under those circumstances?
Members of the Commission, Mr. Kronthal, the applicant who applied for the exemption, could appeal this decision to the Superior Court. If he prevailed, then the exemption would stand. If he did not, then he would not have an exemption at that point, and he would be in violation of the noise ordinance. And at that point, city staff would have to decide whether to move forward with the code enforcement case, and would either move forward or either through administrative citations or other administrative processes, or through prosecution would enforce the code.
Thank you for that. The other question I have is that when you receive an exemption, is there a top to the violation threshold that you can have, and anything over that is still a violation?
I'm not sure I understand.
All right. So the exemption was for these air conditioning units to operate without further attenuation. However, does it say that the 62 dB is sufficient, or if you go over that, are you now in violation of the code? What does the exemption, how is it applied? So if you get an exemption, are you protected forever from even a malfunctioning air conditioning unit, or from, 3 of them singing in concert at a higher dB? Those are my questions.
The code is lacking language, is silent on that issue, but if there was some sort of malfunctioning, we'd obviously have to go out and remeasure it. Even if there's an exemption granted, if there's a complaint that the air conditioner is now louder than it was during the exemption, staff would have to go out there and we'd have to at least do one measurement to determine if that were the case. And if it was still operating within assuming it was the 62 dBAs, that was where the exemption was granted, then yes, the exemption doesn't have a time limitation under the code. Interestingly enough, a variance does. A variance, if they had sought a variance, it would be for 1 year, but the exemption does not have a time limitation under our code.
Thank you. Clarifications.
A follow-up question. Who would defend, should the applicant appeal or take a writ to Superior Court, who would defend against that?
As far as the city is concerned, you mean?
It would be, correct, it would be the city attorney's office.
All right.
All right. Well, I thought that information was important for us, some of that. I don't know if you all did.
Absolutely. I am, since everybody's playing the Cheshire Cat, I'll go first. I am of the mind to move to overturn the decision by the deputy director. The terms of the letter that was issued by him in September 11th make references to reasonable the term reasonable is thrown around many times. I honestly don't think that the parties, either party, did a good job of lining out the alternatives available and the cost that would render that alternative unreasonable. To begin with, I don't even know what unreasonable means within this context. Neighbors that have gone at it, hammer and tong, for, what is it now, 13 years? Maybe some of that time could have been spent hammering these things out. Nevertheless, here we are, and we have what we have to work with. The statement, therefore, the department finds there's no reasonably feasible measures which can be taken to further reduce the noise generated by the unit such that the noise complies with the levels specified in the city municipal code. That is at the end of the letter, but in the beginning of the letter, well, actually in the middle.
Mm-hmm. Are you talking about the sound wall?
Yeah. However,
Oh,
the
second
department.
page? Yeah.
However, the department also finds that the measured readings at the property line exceed those allowed. The city conducted interior noise measurements with the machinery operating, but not interior ambient noise readings with the machinery off. It is not clear that the interior noise readings would be would be with the windows closed. That to me indicates an incomplete record just to say hello. And the fact that the alternatives have not been lined up. We have noise baffling walls or some technology that has not been shown to be effective, documented to be effective, not shown to be. Maybe it is. I don't know. So with that, that's where I stand.
Thank you, Commissioner Munikian.
I will tell you what my views are on this thing. I mean, on the face of it, 13 years sounds a long time. And I don't know how many times you guys have engaged each other to sit down and talk about this thing. You just heard one commissioner articulating his sentiments on the direction that he's going to be taking. I believe in a non-planning solution for this thing. I think as opposed for us to, because of the lack of documentation or the presentation on either part, for us to force either one of you by reversing the decision, my preference would be a continuation so you and the applicant can sit truthfully, think about this, because now if we are going to be overturning the decision, the alternative is to go to court. Tremendous amount of expenses and so forth, and I don't know if that's a right thing to do. My idea, Madam Chair, Mr. Manoukian, is to take the the contrarian view on this thing. I would suggest for this to be continued, for you folks to get together. See, a muffler and a blanket may not be enough. A wall may be the other extreme. I don't know what's in the middle that both neighbors can come to an agreement. And that would be my suggestion at this time.
Thank you, Commissioner Stoyan. Commissioner Shabazia.
Actually, that was very interesting. So you were suggesting a motion that we actually don't have here.
It's not the first time, it won't be the last time. That I can assure you.
Actually, after reviewing and after hearing both sides and the staff, what I had in mind, and I know this has been a battle that's been going on for a long time, to not have this go further, and from what I understand has been studied, I was to go with what the deputy had already decided back in September of last year. But after what Commissioner Asadorian just suggested, I think that would be a pretty good step actually to take, to have you guys maybe sit down and see if there's a possibility for any other alternative to the solution, rather than drag it in a legal battle, time and money involved. What is your 2 cents?
Well, ladies and gentlemen of the commission, Mr. Sturion's modest proposal to spend money on solving the problem as opposed to a court battle, the reasonable solution to me. I would be open to continuing it to allow
Oh, okay. All right.
to allow the two parties to come to a different conclusion. If not, we can then make a decision at the next planning commission. I would be open to that.
The question is, yes, please go on.
So a third alternative to a continuance to a date certain,
Right.
60 days hence, something of that,
That would be
nature.
fine.
Okay.
Can I see a...
And if
Yes, sir.
if I may add, I have no interest for you folks to come back and say, well, here it is, it's the muffler and the blanket, and no, it's the wall. There's got to be something that can be worked out that everybody is happy. I believe that can be done. And now, whether or not it can be done, we'll find out. But in other words, if you're going to come back with that, then, I don't want to preempt another decision at that time, but that's where I'm at. Okay.
So may...
If I may, just so I can understand the Planning Commission's thoughts here, would the Planning Commission also want staff to go out and gather the missing information, perhaps, with the property owner's consent, of course?
And what's your understanding of the missing information? I just want to be...
What Commissioner Minuchin alluded to, where we didn't have certain noise readings.
With the
redo the
windows
test.
closed, et cetera.
Yes.
And I think having all of the metrics that the city does, who may be a non-biased, although may not be because we have a decision we're defending too, would be, I think, important to have in the record.
Okay.
Well, I was, based on what I was hearing, I was thinking more in terms of this is just, it's unfortunate that we are all entirely too many lawyers in the room, but as a general proposition, mediate between the two parties. Bring them together, get the science, get the data in place. Each party says, okay, these are the things that are possible. I've seen this done before, and this is how much it costs. And we try to just fashion a solution which is amicable and under the watchful eyes of the department.
And I might suggest that using an acoustic engineer is a better idea than using an architect, because they are going to make the solution of it. You do not have to use the appellants. We're in Hollywood. There are tons of them out there. So I would recommend using an expert in that field, and they may come up with reasonably priced solutions.
So then what we are requesting, Madam Chair, is that a new sound test to be done by the City of Glendale.
Thank you for that clarification.
So may I have a motion fashioned by one of you?
So I move to continue the case and give the appellant and the applicant an opportunity for the period of 60 days to be able to, for the lack of better word or a legal, will rehash this thing amongst themselves, and with the inclusion of the City of Glendale's participation, namely conducting the sound test one more time the way that it's going to be sent. Excuse me.
So the continuance would be to August 16th.
60 days.
60?
16th.
Madam Chair, I think they may have an issue with the timing, so.
Who is this?
Who may have?
Mr. Ramsoff?
Yes.
You approach us
17th.
quickly.
August
And it's
17th.
only about the date?
No, it's about the noise tests. I don't believe that there's anything in the code that compels the testing of indoor. The indoor testing is
Well,
specific.
we have.
I
We're
understand that.
the city now.
I understand that.
This is a discretionary body. We can.
Yeah, we can
Okay,
do this.
okay,
Thank
okay.
you.
Thank you, ma'am. Thank you.
On the 16th, I may be still involved in
17th. No, it's the September? Wait, August. They want to do August.
I think that's something we can consider. Is everyone here?
Madam Chair, members of the commission, the date is actually August 17th. That's the Wednesday of that.
Well, that still could be time that
That's still
he's in
bad.
the arbitration.
Yes. That would be the probable last day of the arbitration hearing. I wouldn't, it would be impossible for me to do both.
I think so.
Okay, so Monday is fine. I mean,
Well, what about
90 is fine, I suppose.
days?
90 days is fine.
You had something to say, sir?
Very, very quickly, in
Seven.
regards to the testing, there is a difference between nighttime
Or the
and
21st.
all time. That is in the code. So I would prefer that testing is done.
Well,
You know,
Yeah.
we will.
How
Thank
about
you.
how about if we use the word comprehensive sound testing?
Okay.
Covers
That's-
a variety of sins.
the stuff that needs to be.
Yes,
The
and you all can
discussion
have
we
these
need to have.
discussions among yourself because you're going to have to agree to it outside of this room.
All right.
We don't know who you are, so.
My name is Victor Ramsey.
And actually, the public hearing is closed, and since we haven't heard from you, Victor, I'm afraid that we can't hear from you. Thank you, sir.
For 90 days.
All right.
All right, so
So I've made a motion. Has it been seconded?
I second the motion.
Can we get a
did you
date
read the
certain?
motion to us?
September 21st.
21st.
No, he stated it. Somebody was writing it down.
Okay.
Who wrote down the motion?
Moved by Commissioner Astorian and moved by Planning Commissioner Shabazian that the project be continued for a period of 90 days,
To September 21st.
September 21st.
Without
The
further
inclusion of the
notice.
city's participation conducting a comprehensive sound test.
Without.
Does that cover it, sir?
And can we also add facilitating the communication between the parties?
Solicitate communication between the parties.
By the planning staff.
Yeah, we'd like
Planning
Mr. Kraus,
we'd like to add to that they would be without further public notice.
without further public notice.
All right.
All right.
So there's a first and a second. Roll call, please.
All right. Thank you, sir. Roll call, please.
Planning Commissioners Astorian.
Yes.
Manukian.
Yes.
Shabazian.
Yes.
Chairperson Landry.
Yes. Thank you. We will take a very small break here, and I am going to let you know that that is passed with a continuation, and then we will have the second item in about 10 minutes. You all have to have your cell phones on here. I'm kidding. It's a joke.
Okay, we're back on, Stephanie. We're back on.
All right. We are back in session. This is the June 15th, 2016 Planning Commission meeting. Thank you. And any further ones, if you would hand them over to the secretary and who will send it to me. Thank you very much. We are continuing with Planning Commission items number 7. We have no old business. We do have new business. Wireless telecommunication facility permits. Case number PWTF 1523946. And may I have the staff report? Hi, Kathy.
Thank you, Madam Chair, board members. The proposal is to operate a new unmanned wireless telecommunications facility and ancillary prefabricated equipment building located at the southeast corner of Dunsmore Park. The proposed facility consists of a 60-foot high support structure disguised as a pine tree, which we call a monopole, with 12 8-foot antennas and also an 11-foot by 21-foot ancillary equipment generator building within an approximate 600 square foot leased fence premise. And as a little bit of background, Dunsmore Park is located approximately 0.3 miles north of Foothill Boulevard on the east side of Dunsmore Avenue. This 9.8-acre neighborhood park opened in 1960. The park serves a portion of the La Crescenta area and is adjacent to Clark Magnet High School and is across the street from Dunsmore Elementary School. The site slopes to the south and contains Milton Hofart's eccentric stone walls, as well as a building that remains from Mount Lucan Sanitarium, now used as a community center. Dunsmore Park offers a full range of amenities, including a lighted ball field, children's play area, picnic area, tennis courts, and wading pool. As I noted, the telecommunications facility is proposed at the southeast corner of the site, which is south of the existing ball field. Park staff did go out and recommend this area as the most appropriate site for the wireless telecommunication facility. They felt that the area was not used as much or wasn't used, and it wouldn't take away any recreation from the park. The proposal is classified as a Class 6 antennas and is subject to the approval of Planning Commission at a public hearing because the facility is located in the SR Special Recreation Zone. There are no height requirements in this zone. Staff found that the required findings for a wireless telecommunications facility can be made as noted in the staff report. We did receive comments from other city departments. Our Information Services Wireless section found that the subject site does appear to be necessary to fill a significant gap in coverage for the applicant's network. Building and safety required their standard conditions for obtaining a building permit. And Community Services and Parks needs final plans to receive approval from Parks, and an agreement must be signed with Parks. Planning staff does recommend that Planning Commission approve. Oh, before I say that, we did have 3 letters in opposition, which you have received. We do recommend that the Planning Commission approve the applicant's request, and I'd be happy to answer any questions if you have any.
Commissioners, any questions for Ms. Duarte? Thank you. All right.
Madam Chair, I'm sorry. I do have a question.
All right, sure. Mr.
Maybe I'm misreading it. But in your staff report, staff recommendation, it says the planning staff recommends that the Planning Commission approve the applicant's request to install and operate a new unmanned wireless telecommunication facility. New, right? Correct. But in your findings, the reference is made to, it's number 6 if I'm not. In one of your findings, a reference is made out to an existing. It's number 1, I believe. Actually, the reason why the environmental impact report is not necessary is because it's an existing site. Is that an oversight, or am I reading something into that? I'm trying to find it. I should have underlined it.
I don't see what you're referring to. However, this can be categorized as an existing class
here it is.
1
it says,
or
yeah, exactly.
Existing
It says
facility
class
class 1.
existing facility class 1. Alteration or negligible expansion of an existing use. I mean, that's in direct dichotomy with what your second line of your staff report says, that this is a new and unmanned. Am I reading this wrong?
Existing facility referring to the existing park site, which has
So it's not
utilities.
Okay.
It can, either way, it would be categorically exempt, either as a class 1 existing facility or a new structure.
Let me ask you this question. Is the existing facility the park or?
The park.
Okay.
But then when you reference it as negligible expansion of an existing use, you really don't have the antenna use at this time, do you?
And it's not a recreational use.
Point taken.
Well, it is for AT&T, but perhaps not for us.
And it could be for other users. But.
Madam Chair, members of the Commission, I think you're referring to the environmental determination. So essentially, it really can be viewed as one or the other depending on how you're looking at it. In this case, we looked at it as the parks was the existing setting, and it's a modification to the existing park. But it could also be a Class 3 under CEQA as well. So either Class 1 or Class 3 is appropriate under CEQA in this case.
Okay.
All right.
Thank you.
You're welcome.
Other questions from commissioners? No. All right, thank you. Our applicant is Mr. Jerry Ambrose. Please, you have 15 minutes, and please state your name.
Good evening, commissioners. My name is Jerry Ambrose. I'm here on behalf of AT&T. I expect several questions tonight about the hows and whys of how we came to this particular location. So I believe staff included a packet with some information, some coverage information. Is that correct?
Correct. Yes.
Okay. So I just want to run through that real quickly. This map here is essentially a technical map of AT&T's existing service. The green is the center of the green spots is where their currently cell sites are existing, and the fuchsia and white areas are the areas where a new site is needed. And the purpose of the project is to fill a gap or a hole in the network between these other two facilities, and you'll be familiar with where they are based on the streets. So when we're out looking for a project to fill that gap or that hole in the network, the search area that we call it, in order to resolve that gap, is shown in this map here. And this map outlines all of the potential sites that we looked at and the reasons why we did or did not pursue them. And there were 8 total sites that we looked at. And in order for a potential site to be viable, we have to have a site that meets the technical requirements of the network. It fills in the significant gap. We have to have a site where there's a willing property owner to enter into a long-term lease agreement. And we have to find a location that meets the zoning requirements, or at least is allowed, subject to a discretionary action by the city. So with those requirements in place, as well as the hole or the gap area in coverage, we determined that the Dunsmore Park was the best, and at this point, the only viable solution that we have for this particular project. It is owned by the city, obviously, as you know, and the city does have a program for allowing these types of facilities on city property. They have a standard lease agreement, and as staff mentioned, we did work with the Parks Department on where they wanted us to go. It's a very large park, and they felt that if we were sort of on the side, sort of out of the recreational area, that would be best. and that meets AT&T's technical requirements as well. And with that, I'm here to answer any questions that you may have.
Thank you, Mr. Ambrose. Commissioner Astorian has some questions for you.
Mr. Ambrose, you have 8 sites that you have listed on this list that you have.
Correct, we looked at.
In all honesty, the first 3 sites are true alternatives. The other 4, from 4 to 8, cannot be a true alternative because it's of the distance anyways.
Right, but we look at those, though we say, hey, those are close by, let's go look at them, because you're limited by zoning, by residential development primarily. So we look at those as, hey, will this work? And the engineer guy says yes or no, owner says yes, or that kind of thing. So we have to run it through the same test of the 3 criteria with the owner, zoning, and the technical requirements.
So by federal law, do you have to have a specific number of sites that you have to look as alternatives?
I'm not an attorney. I don't know the exact answer to that. 8's a pretty big number, especially in a residential area. But you know the federal law basically the city has to determine that we've exhausted all of our potential viable alternatives. That's the basics of the law.
Right. And so what I'm getting at, sir, is that the last 4 are not viable alternatives because they're farther away from the area of your coverage.
They're outside, correct.
So those are not really, they should not have been listed anyways.
It's just an exercise of going out in the field, finding locations. The city asks us to look at alternative locations. We want to cover all the bases. So that's what we've done here.
But that sounds like when my wife sends me to a grocery store to get cucumbers and I come back with tomatoes. I mean,
what happens at a lot of these hearings is people come out and they say, hey, why don't you go there? Why don't you go over there? And we have it here on the map. It's shown, so if it needs to be referenced, it's shown. That's very helpful when people come up and say, hey, go there, I want you over there. Or they start pointing to different locations. So that's another reason for it.
Thank you, sir.
Yep.
Any other questions?
I have a question, sir. So on this page, there is a search ring that you show.
Correct.
And Dunsmore Park is actually outside that ring.
Just to the west of it, correct.
Correct. So is just an area you guys picked, or was there a specific reason why you focused on that area and only looked at that?
Yeah, if you go back to the original map that I showed you,
yes,
that's the gap or the hole in the network right here.
Okay.
So, cell site means that they sell to sell to sell, they hand off. So ideally what you want is a site right in the middle of those 2 existing sites so that the sites can communicate with each other. So that search area, something within that search area should resolve that issue. If you go too far west, you're going to be too close to this one. You go too far east, you're going to be too close to this one.
I see.
North, you're in the mountains, and south, you're at other sites that are below. So it's, like I said here in the map, it's just an approximate boundary. A lot has to do with the height. If we were only getting 30 feet of height or something, well, obviously the signal wouldn't propagate. So it's height, geographic location, and location in relation to existing sites, trees, other obstructions that might be in the area, a lot of factors.
Thank you.
Mr. Minukian? Commissioner Minukian, all right. Thank you, sir. All right. I have several cards here. And you will have 5 minutes, but does everybody want 5 minutes, or shall we go with 3 minutes? 5 minutes? All right. Mr. Rain Gibney. Oh, Ms. Rain Gibney, my apologies.
Hi, my name is Rain Gibney. As I read through the proposal for the cell tower at Dunsmore Park, one phrase kept standing out, and that was compatibility with the community. The proposal seems to define community compatibility as a fake pine tree. I think it goes a lot deeper than that. As a kindergarten teacher at Dunsmore Elementary School, directly across the street from the proposed tower, I teach my students about what a community is. And it's a place where people live, work, and play together. I live in the community, I work there, and I play there at the park with my kids. I'm guessing Mr. Ambrose doesn't. A community is made up of places and people that look out for each other and I am grateful that the people of the community have the opportunity to speak tonight. And by community, I mean the Crescenta Valley. I would argue, however, that they have already spoken. In the proposal for the cell tower, it clearly states that AT&T considered alternative sites. It should be very telling to AT&T and to the city of Glendale that no Crescenta Valley community entity was interested in leasing them space. Not schools, which are always desperate for money, not churches, and not the local water district. It even says in their alternative site analysis that there is opposition from the CV Town Council, neighbors, and the Board of Supervisors. Apparently, having a cell tower on any of these properties was not compatible with their view of the community. I am hoping that the city of Glendale, though somewhat removed from the Crescenta Valley, shares their view. And going back to my kindergarten class for a moment, I have 5-year-old students in my class that have cell phones. If given the choice, many of these 5-year-olds would rather play video games on their cell phone than run around at the park. As a parent and a teacher, this doesn't surprise me, but it does sadden me. By approving AT&T's permit for a cell tower at Dunsmore Park, Glendale would, in a small way, be validating that that's okay and putting cell phones as more important than park space. That's all I have to say.
Thank you. Rola Masri? Did I say that right? All right. Thank you. Please give us your name, and we'll start the timer for you.
Okay, my name is Rola Masri. I'm a 5-year resident of La Crescenta. I'm a scientist by degree and also a mother of 3 children. And we go to Dunsmore Park a lot. My kids play AYSO, and we have practice there. We have clock magnet. We go to a lot of games there. So this is a really beautiful park for us, and just so peaceful and nice. Several years ago, Wi-Fi was put into my children's school, and I did so much research. I became the expert on wireless technology and its health effects. And what I have found is crippling to a mother, just to see how this technology is being proliferated and with zero regards to health effects. From my research, and I can actually forward all this to you, I've come up with over 900 studies, abstracts. This is from what I've done, but there's also a lot more. There's thousands that show all kinds of damage that can be done to humans, anywhere from DNA damage, cancer, neurological effects, heart issues, all kinds of organ issues, effects on the thyroid, the hormones. There are people that become electrosensitive, and I learned the hard way, or maybe I guess it was a blessing that I am electrosensitive myself. And I feel like the world is closing in on me. When I learned that my kids were going to get Wi-Fi in their classroom, I'm a scientist. My husband is a Boeing engineer. We have technology in our home. So it was everywhere, but I was sick. I had heart palpitations, headaches all the time. I couldn't sleep at night. And I would go to all kinds of doctors, ringing my ears. I went to specialists for my ears, for my heart, for my thyroids, everything. They couldn't find what's wrong with me, but it wouldn't stop and would just get worse and worse. So when I learned that there's Wi-Fi in my children's schools, I wanted to... I did some research because I'm a scientist, and I wanted to see if this is safe. I'd heard something about cell phones not being safe, so I wanted to see if Wi-Fi is safe. And what I came up with was all of this. And I said, you know what, I'm going to turn this off in my home. I'm going to wire everything in my home so at least my kids being exposed all day to Wi-Fi can have a safe place to be at home. And what happened was a miracle to me. I had no idea. My symptoms just shut off after 7 years. I experienced nothing. No more heart palpitations, no more headaches, no more ear ringing. all the anxiety, all the insomnia completely went away. So now I go back to a park because my kids play soccer, they play a lot of sports, and I have to go to these parks. I'm sick for 2 days afterwards. Please don't take away our Dunsmore because I feel so good when I'm there. Okay. So this is what I have to say about that. But I also want to talk to you a little bit about what I've learned with all the research I've done. Over here I have an article that was written by a professor at New York State University. She talks about the hidden insurance risk lurks in property leases. So she talks about how the city will be liable for any injuries that would be caused by cell towers, not the cell tower providers, not AT&T. It'll be the city because you have allowed them, and they probably have some fine print somewhere that tells you about the health risks, but you will have allowed it to go on a property that is so close to Clark Magnet. There are all these houses around there, and there's an elementary school across the street. These cell towers don't belong in residential neighborhoods, and I will hand this over to you.
Please hand it to our secretary.
Want me to make
She'll
copies?
pass it to us. Thank you.
I will also hand you over
Okay, wait, Shanas.
Swiss Re is the biggest reinsurance company that talks about wireless as being a high risk. The potential impact is high, and it's an unforeseen consequence of electromagnetic fields. And they talk about it as being something that will show up in about 10 years of exposure. And I'll hand that over as well to you.
All right, thank
so
you.
Insurance companies that will be paying up for health risks have a vested interest in learning about the health effects, and I think we need to listen to them because AT&T is going to show you that everything is fine because they have hired their own scientists, and it has been shown that the research that the industry is putting out is showing no effects because they're not testing long enough, they're not testing the right things, whereas independent scientists are showing health risks. As a matter of fact...
Thank you, Ms. Massari. If you would please wrap it up. You
Okay.
had 5 minutes.
All right. As a matter of fact, in Italy, somebody was just awarded for a brain tumor a lot of money, and the Italian courts said that the industry was putting out research that they couldn't use, whereas the independent scientists were showing health effects, and that's how that person was awarded. It was the first claim that was being awarded, and now there are dozens of claims in our United States that are in the courts right now. So,
thank you for that information. I'm sorry I cannot read your name, but it looks like Mideli? Michelle? Michelle. Do you have a last name, Michelle? All right, you can add that to us afterwards.
Oh, okay.
Thank you. Please come forward and introduce yourself.
Michelle DeLauder. I'll keep this short, but I want to say I'm absolutely opposed to this. This is one of the best green space parks that La Crescenta has. It's a park that everybody goes to. It's a huge recreational park. It's not just soccer. It's not just baseball. I walk my dog there every day. I've walked her there for 13 years, 13 and a half. I've met wonderful friends up there because I walk my dog every day. I chose that park out of so many different parks up in that area because it is so beautiful, so calming. He says it's not a recreational park. People go up there every day, every minute, every hour. They walk, they jog. I have a friend that her mother was 97 years old, walked up there daily. She lives 2 seconds down the street, but she was there. So I just want to say that I totally disagree with this taking away green space, peaceful space. And the few minutes that I have left, I want to give to Kevin.
Well, you got to fill out a card.
Yeah, filled out.
He has a
I filled out a card, but she was going to cede me her time because she wanted to cede me her time.
Well, that's with our permission.
Is it okay for? Sorry.
So
is it okay
you
for her
want
to cede
more
you
than
time?
5 minutes?
Absolutely. Absolutely.
All right, you can do that, and then we'll start that. But don't take 1 second more, Mr. Wilby.
Okay, so her time and then my time.
That's me. Who's Kevin? What's your...
Kevin Matis.
All right, continue, Kevin. I'll
Okay, so
find
take
your
her
name.
time and my time, too. Don't go a minute over. I got it.
Thank you.
Can I just hand you?
Please hand everything to the secretary,
Hand one of these to each person.
who will hand them out to us in the back. Thank you.
I'll wait till you get those.
Your time is going.
Okay,
I
so
just say start.
Okay, I didn't know. Okay, so my name's Kevin Matis. I'm with the California Brain Tumor Association, and we work with people who have developed cancer from wireless transmitters, cell phones, cell towers, smart meters. And I came here today because we're working with thousands of people, and people are definitely getting sick from this technology. There's been a great, grave injustice happening when it comes to wireless technology and health effects. I was impressed by the question you were asking. Why hasn't an environmental review been done on this? That they're being exempted from even considering the health effects and the environmental effects, and that's a real travesty. And that's why the other areas around here, they know about the real injustice that's going on, and they've said no to it. If you look at the handout I gave you, just on the front cover, it's important because this study just came out 2 weeks ago. It's a $25 million study done by the U.S. National Toxicology Program, and that's the official U.S. government's arm to look at the toxicity of agents. And what they found is that wireless radiation, specifically the radiation used by wireless companies, causes cancer, specifically brain cancer and a very rare type of heart cancer. And this is a very important study. It's the most important study that's happened in the last 20 years because all this happens subthermally. They didn't allow for any thermal effects. Now, our safety standards only take into account thermal effects. So it shows that our safety standards are completely inadequate. And due to this study, we believe that they will seriously revise our safety standards because it shows that they're missing the boat completely, and that's what's been the story from what you hear from people getting sick all the time. If you look at this also, what's interesting, if you look at, and this is their official press release, at line 19 it says, even a small increase in the incidence of disease resulting from exposure to radio frequency radiation, and it is radiation, could have broad implications for public health. And locating this near a school, near children, is completely inappropriate because they're the most vulnerable. If you look at page 2, this is a letter from Martha Herbert. She's a pediatric neurologist from Harvard. And she cited, if you look here, it's underlined, she cited 550 studies showing neurological effects. So we know it's neurotoxic. That's what causes cancer. It also causes neurological effects, like the woman was nice enough to talk about. And she says children shouldn't be exposed to it. Their exposure should be minimized, and we should use wired connections. She specifically wrote this letter to LA Unified. So I think we need to take this into account because understand that our safety standards are established by the FCC, and they're maintained by the FCC. And the FCC has nobody with a biological or medical background in the FCC. So it's a big joke that they're holding the safety standards. Now also understand this, they aren't safety standards. They're safety guidelines. Because if you have a safety standard, you have to have the research to back it up, and they don't have that research. They're just assuming that if you don't get burned by your wireless device, then it doesn't hurt you. And they're assuming that it should be exempt because we know that this cell tower is not going to burn anyone, so we can exempt it. But if you continue on, she talks about those 550 studies. If you look at page 3, Not only that, we now have the mechanism for how it causes cancer and neurological effects. This is from Washington State University, and he outlines exactly how it causes it. That is, our cells are electromagnetic, and these electromagnetic waves, and just so you understand, regular Wi-Fi is 2.4 gigahertz. That's 2.4 billion electromagnetic waves per second hitting your body. You can't see, feel, or hear it, but your cells are electromagnetic, and they respond to it. And what this...
Please give him 5 more minutes.
Thank you. Thank you. And what he shows in the mechanism is the cells have a sensor, electromagnetic sensor, and they open up. And it allows free radicals in this case, calcium. And that calcium can cause electrical symptoms if you're electrosensitive to it. Or over time, the free radical damage over time causes inflammation and cancer. So we have the mechanism now. Other countries are preventing and minimizing people's exposure, and we're still pretending there's no health effects because the industry has such influence and there's such an economic interest in this country. If you look at page 4, this is from the Department of Interior, our own government, okay, and they wrote a letter because they're rolling out more cell towers across the country for emergency response. They wrote a letter, and you can see the letter right here. I included the entire letter because I know this group is very thorough. If you look at the letter on page 9, you see on attachment A, they say this in the second paragraph, the second significant issue associated with communication towers involves the impact of non-ionizing electromagnetic radiation emitted by these towers. Okay, and they talk about how there's been nest abandonment and death of animals. So if you don't want to take into account the health of people or children, take into account the health of animals, because they're saying clearly here that these cell towers for nearby locations are killing wildlife. And this is from a federal agency. And what's interesting is, it's in this letter, but if you turn back to page 4, this is from page 4. This is from Joel Moskowitz. He's from the University of Berkeley, and he's a PhD scientist, been following the research worldwide. And he says clearly in his review of this letter, this is out of the letter, the electromagnetic radiation standards used by the FCC Commission continue to be based on thermal heating, a criterion now 30 years out of date and inapplicable today. So we have a safety standard in name only. It's not really creating any safety for our people. And the reason all these communities are coming out against it is people are getting sick. It takes time for people to get sick, but they get sick. Electrosensitive people are very important because they can get sick almost right away. And they're telling us that this is a harmful agent. But this is the federal government confirming what we're talking about and stating it. The problem is the FCC that regulates this is firmly controlled by the wireless industry. The new chairman of the FCC is the former main lobbyist for the wireless industry, and he's the former CEO of the Wireless Trade Organization. We have a Verizon attorney as one of the commissioners, and we have other wireless entrepreneurs and insiders. So the people who are supposed to be regulating this technology are the ones benefiting from it. So we have a clear conflict of interest. Now, such a conflict of interest that I only have one. Harvard University put out, this is from their ethics department, put out a 75-page report talking about how the FCC is a captured agency. It's corrupted. It won't look at health effects, and it has serious consequences, and it's been this way for years. They went to the trouble of writing this report because real people are getting sick, and this is a real injustice. So I'm going to leave. I only have one, so I'll give it to the chairman, please. But you can look over it in more detail. So that's the real critical problem. If you look at page 13, this is the bioinitiative report, and you can look it up online, but this is the summary, page 13. They look at 1,800 studies showing a variety of health effects from wireless. Immune system compromise, reproductive harm, neurological effects, cancerous effects, DNA damage, and a host of other things. Basically, we are microwaving our population. These are microwave transmitters, and that's absolute fact. They transmit in the microwave frequency range, and we are microwaving our children with it. Cell towers are the most powerful transmitters we have. And to locate them near people's, near schools, near parks, is completely inappropriate, and other countries are doing things to protect their population. You'll see in this summary, the next 3 pages, she talks about DNA damage, and if you go to their website, bioinitiative.org, they list all these studies and review them, and they are peer-reviewed studies. What's interesting, if you look at page 16, The California Medical Association has come out at the end of 2014 and passed the resolution. If you look at page 17, the resolution says that we support the development of new safety standards that do not cause human or environmental harm. That would be nice. That number one is that take into account these non-ionizing or non-thermal health effects. And that was written by 2 doctors, and that was passed by the California Medical Association. So we should be listening to these bodies that are full of qualified medical personnel and not the FCC that is really actually mandated to promote the industry and expand it, and they've done a wonderful job doing that, but they haven't taken into account health effects. If you look on page 18, this is the press release from the Los Angeles firefighters who were able to exempt themselves from having cell towers put on top of their stations. And you'll see on their press release, and this is official press release to the right, they state that, and they commissioned an expert, that the symptoms near a cell tower, chronic stress, poor sleep, headaches, memory problems, heart problems, and cardiac problems, immune system dysfunction, and they were able to get exempted because they put in their motion that they needed to be efficient and effective for their job, so they shouldn't have cell towers put near their stations.
So thank you. You may give me one sentence wrap-up.
Okay. If you look at page 19, they list a host of studies that all are peer-reviewed, and the Board of Supervisors moved to exempt them from any type of cell towers near their facilities due to radio frequency radiation. Now think about the children who we know are 4 times more affected by any kind of hazardous agent and how they'll be affected. And shouldn't we give them the same kind of privilege that we give the firefighters, who most people would say are pretty strong and pretty strapping?
Thank you very much. Any questions?
I have a question.
Sure.
Mr. Mathis, right?
Modest. Close enough.
I mean, you seem to have been well read on this subject area. So, what is the distance that is appropriate?
Absolutely, because I'm going to get to that later.
All right, but just
answer my
Just answer the question, please.
I'm going to answer it, but try to be thorough.
Okay.
So, Los Angeles Unified School District set a setback for cell towers of 200 feet. The idea is good, but the distance is bad, because the highest intensity for a cell tower is 250 feet. And they even said that during a cell tower meeting in La Crescenta. The experts said that. So they made it 200 feet. That puts them right in the highest beam. Really, the studies show 2,000 feet, because they're showing neurological effects, learning problems, reproductive stuff, and cancerous issues over the long term up to 2,000 feet. Right now, we have 0 setback. We have 0 precautions in terms of warning people about how to use cell phones. We should require that everyone use a headset. We should require everyone, but the kids don't. We could use a frequency that's less bioactive. It still carries data, but the one we use now penetrates very well and travels very well. But it's also very bioactive. We can see changes in the blood and stuff from it. But we could have a frequency that was less bioactive, but then you have to look at the health effects, and they don't want to do that.
Okay, thank you. Any other questions for
Thank you.
Okay.
Mr. Mathis?
Close enough.
Modest.
Modest?
Modest.
All right. Thank you, sir.
Okay.
I did take a quick look at captured agency here. And it's something that everybody needs to realize, because we are restricted in what we can review. And you know that. It says no state or local government, within your booklet here, or instrumentality thereof may regulate, we are an instrumentality thereof, in case you are wondering, may regulate the placement, construction, and modification of personal wireless service facilities on the basis of the environmental effects of radio frequency emission, to the extent that such facilities comply with the Commission's regulations concerning such emissions. So there are it's not a discussion we're having here because you gave this to me.
I was just confirming.
And so we are limited in what we can consider when the placement of wireless is proposed.
Any reason you can decline this application would be appreciated.
Okay. Thank you, sir. So we will continue.
Madam Chair?
Yes.
No, I guess I'll hold on.
Do you want to? It's all right. We can. I think keeping it within
I just wanted to say, and the city attorney can confirm that health issues, as grave as they may be sounding, are not within the purview of this commission when it comes to wireless approving or disapproving. In other words, if we were to approve or disapprove a wireless facility, it has to be based on compatibility and it has to be based on site selection. Those are the 2 or 3 ways that we can judge, deny, and request additional. So health cannot come into the conversation, as brutal as that sounds. Ma'am, this is not for discussion.
I just want to make a correction, though. Environmental, not health.
Well,
the actual law says environmental. They expanded it in a court case, but actually the law is environmental.
Here's how the Planning Commission works. We ask you all to come forward and give your testimony. We can ask you questions. It may not be the most perfect dialogue, I apologize, but that's how a planning hearing goes. The applicant will have a chance to rebut, and we want everybody to have their 5 minutes. But if people take more, we'll be here later, and it'll take time. And I just want to comment on things. We want to comment on what we hear. That's why we're here going to be the deliberators. So I hope that is something that you all can understand and appreciate. So the next individual will be another Kevin. Kevin Wilby.
Hello.
Hello. Please identify yourself, Mr. Wilby.
Okay, my name is Kevin Wilby. I live at 4811 Cloudsdale. That's across the wash from the park, Dunsmore Park. Thank you for having me here so I could tell you why I am against this monopine. When I first got your notice, my sister was there. I said, "Oh, we're getting a monopine." And she said, "Oh, my God," because she lives in Laguna and it had a flat tire along the road next to a cell tower. And she said, "Yeah, we're there trying to fix a tire, and the signs all said, 'Don't sit or stand near this place.'" And I thought, great, we could put up a sign, "Welcome to Dunsmore Park. Do not sit or stand near here." And you may think I'm just some nut talking about microwave radiation. And if I may get to the other Kevin's point, the point was the people making the regulations are in the pocket of the people who are being regulated. So, yeah, you can't make the decision on this, but we still need to know about it. And so, yeah, I'm old enough to remember when the Soviets were blasting the Moscow embassy with microwaves and everybody was getting sick. And we have a long tradition of risking the public's health when it makes money for rich companies. Lead in paint, in gasoline, solder pipes, water, Flint, Michigan, asbestos, exploding Ford Pintos. I remember when smoking had ads that implied it was really good to smoke, and some of these have been disproven. So, at any rate, I went to the monopine, which is now actually a monomagnolia, because all the needles fell off due to the UV, and then it looked like hell for a few years, and then they put on big leaves. And so I went and I saw a double chain link fence with a lot of warning signs. And, of course, the double chain link fence, this is the area where the illness can be pinned on the cell tower. They could say, yeah, without a doubt, if they sue us, we're screwed here. But outside the fence, yeah, I could probably argue it's like an exploding Pinto. It's just an act of God. And so this is what we have to realize. So my first thought was, which kids' brains were they planning to cook? There are 2 elementary schools, by the way, St. James the Less Catholic School and Dunsmore, or Clark Magnet High School. So I see they chose Clark, and if I'm not correct, one of those things on the board said that Clark was a potential site, but Clark didn't want it. Where's the monopole now? Closer to the Clark boundary than I am to you. little disingenuous there. So, nothing against AT&T. I'm not saying they're working for the Soviets, although sometimes when I was in a hold of the Philippines, I thought maybe they were. So, any rate, what we are looking for is a way to not have it be in the position where these kids grow up and we discover, oops, microwave radiation was bad. Just like, in the NFL. Oh, my goodness, concussions. They cause problems? How could that be? I mean, I was caught as much by surprise as anyone here. But so health doesn't enter into the decision. So you need something that you can reject this outright. And so here it is. And I thank Mr. Astorian, if I'm pronouncing your name correctly.
You're on the dot.
That you read this thing. On the notice I was sent, it says the environmental determination was categorical exemption, existing facility class 1, alteration or negligible expansion of an existing use. And that is untrue. So they need to go back and start over, because you can't just say, you can't make stuff up, as Mr. Astorian alluded to. Yeah, it's a park. Park doesn't have a cell phone in it. A park is a park. And it's an industrial site, which is what, when I went to the various places, I don't want to run out of time, that's what's being put there. It's not an industrial site that is being altered or expanded. It's a destruction of an existing use. The monopine would dominate the flat area at the end of the left field line. It's an area about from here to Miss Landergan. And all the people walking the dogs go around there, all the joggers. That fence would take up that area. Gone. These number in hundreds of people a day. You may think I'm joking. Sorry.
One more sentence.
You may think I'm joking, but I have a dog that doesn't get along with other dogs. So when I walk in that same place, I always have to be aware. Who's out there? Is it a low point, a high point? Constant use. And, gee.
And thank you.
I have more, but thank you very much.
Thank you, sir. Lee Freidenberger.
Hello. My name's Lee Friedenberger, and I want to say I oppose this tower. I think it's well, you can't talk about the health benefits.
No,
then
you can.
You can.
We can't.
You can't. Okay. Well, I think that's a big issue, but also the fact that they said that the park people were saying that this area isn't used, but as the previous man said, a lot of people walk their dogs and they walk around there, and kids play in that area, and there's like a area where they slide down the hill. I mean, it's a very fun area. And this would totally be taken away. No one would be able to go around there anymore, and I think that would be a big factor. I mean, the park is big, but that's a big area where, people can walk their dogs, and then they don't have to totally be inside the park. They can be kind of around it a little bit. And it's just a health thing. I think it's too close to the schools for the kids. I think that's a big factor. And if I could, I would like to give the rest of my time back to Kevin. Would that work?
I think not.
No.
Okay.
I'm sorry.
All
That's
right.
not our pleasure.
Is there I could do a few more minutes, but I thought I would have.
It's at the pleasure of the chair, and we already gave you additional time, and so.
I was just planning, if I could just do a few minutes, because I was planning on having all the time.
No, I'm sorry. Thank you, though.
Okay. Thank you very much.
Can I turn in one thing to the committee?
Sure.
This
You
is
can
the Wall
turn it
Street
into
Journal
our
article where the
secretary.
industry admits wireless
Our next speaker will be
It's pretty important.
Lori Wilby.
Good evening. Thank you. It's nice to talk to you this evening. My name is Lori Wilby. I live just right on the other side of the wash of Dunsmore Park. I've lived there for over 30 years. What brings, you've heard a lot of things. I don't want to repeat what you've heard a lot of, but I want to talk about that specific corner right there because it's a pivotal part of that park. It's one of the flattest areas. So besides all the organized and recreational sports groups that use the ball diamond, there's a huge contingency that uses the exterior, right? Because your dogs aren't supposed to be inside, people are in there playing, but at any time people take a walk and it's flat. It's one of the flattest places in the park. So AT&T out of the recreational area, the southeast corner not used, wouldn't take away any use of the park. That specific corner, if you look at the map on A2, according to the drawing, the fence around the pine tree, whatever it's called, would directly hit the chain link fence, which would completely block off that walkway there because right next to it is a steep hill where birthday parties occur for sliding down the hill on cardboard. It's a long tradition, decades of use at that specific corner, Dunsmore Park. Another issue with that corner is, according to A2 also, it says those are liquid amber trees, and I do have pictures. That specific tree, the trees that are there are the California sycamore trees, the western sycamore, which according to the City of Los Angeles Planning Ordinance 177404, the sycamore trees are a protected tree, and the 5-foot trench, this would be A1, page 1. AT&T proposes a 5-foot trench coming from the tower down to the extra building, right? So that would directly impact the roots of those trees that are right there, right in that area that we're talking about. So, and as I say, I've got pictures. Oh, and I have evidence of what a liquid amber leaf and pod looks like. We call them ankle sprainers at my house. And then sycamore tree, the sycamore tree leaf and pod. We've done our homework, and according to the guy at Armstrong Garden Center, that's correct, that those are sycamore trees. And let's see, let me just check my notes here. But again, I just want to reiterate how much that actual corner is not a low-use area. It's a very high-use area for, and if we have time, I could happily, easily get a petition with hundreds of signatures of people who use that corner. All right, thank you. Thank you very much.
Thank you.
I'll give my pictures and evidence over here to your secretary. I'm sure it will be very useful for you.
Next up, Jason Beggs.
Hello.
Hello. Thank you.
My name is Jason Beggs, and I'm a teenager that goes to Crescenta Valley High School just by Dunsmore Park. And I live only like 3 blocks away from Dunsmore Park, so I go there quite often. Since summer started, we've been going about 5 times a week. And lately, we've been seeing a lot of people walking around that area, and there's a lot of activity in that area. And I feel like if they put a cell tower there, there's still going to be a lot of dangers for kids, not just by like the health factors of cancer and stuff, just by kids being curious, so they're going to want to be climbing on the fences of that and trying to get on top of it. So I feel like if they put it there, it's going to cause a lot of problems and a lot of traffic there, and people aren't going to want to go over there anymore, so a lot of people are going to start going to other parks and stuff. It's going to cause a lot of problems. And then where it's placed, I think that it's going to not want parents to get their kids there because it's going to be there. So they feel that it's going to cause more problems for their kids. And with the hills there, they slide down with cardboard, and a lot of them, the kids have a lot of fun. And I feel like once the kids grow up to be adults themselves, they're going to want to take their own kids there. And with this cell tower, I don't think they're going to be able to. So I just thank you.
Mr. Beggs, you were here on the
Starbucks. Yes, you're becoming an active citizen. Thank you very much.
Thank you.
It's a good thing.
That's a great
Thank
thing.
Excellent. Thank you. Brandon Budwig.
All right, my friends, I love them. Hi.
Give us
I'm
your name.
Brandon Budwig.
Thank you, sir.
And I am a former Dunsmore Hilltopper, same as Jason Beggs and Evan Curry, who was back there. We graduated 2010, and I don't really have any evidence or anything, so I might as well tell you guys a story. I have a brother who is 3 years older than me. So he also went to Dunsmore, and as a family, me and my family would all go, even when I was little, drive to Dunsmore Park and have birthday parties. And we had 7 in a row at the same place, just because there's so much things you can do at that park. And it's lively, it's beautiful. And as a kid, I did not notice or care at all. I thought it was just really fun, and I loved the play set. When I was in Dunsmore and I came, my teacher would take us with our buddies to go to the park and bond with these older kids or younger kids. I did it when I was in kindergarten, and I did it again when I was in 6th grade. And honestly, they're memories that I have and I hold very close to me. I would be driven by my mom to go to Dunsmore Park with my friends to go hang out and do all the things that we do. And then as I got older, I still would walk to Dunsmore Park with my friends to go hang out there and slide on the cardboard, which you guys should all try. You guys should all try. It is really fun. It is really fun. And now we drive up there. And even though we sometimes find it a little weird to be doing the same things that we've been doing for years, we do it anyway. Just because we're big kids doesn't mean we can't have fun. I hope that when I get older, and if I do decide to have kids, which that's the plan later on, I want to bring them there. I want to share the memories. I want to show them how to slide through cardboard down a hill. I want to show them that. And that doesn't exactly correlate with the radio tower, but what does is if we put this tower in the middle of where the top part of this hill is, which is a path for many dog walkers in general, and just kids for them to run around. They're going to hit that thing. I would hit that thing. I hit trees. So it can be a hazard, especially with little kids. And I'm very sure that a kindergartner or any person that's of that age would be curious and want to climb it like my friend said. Another thing, I think that it takes away the beauty that we have at Dunsmore Park. Everything that we have there took time, and it took a lot of love. The owner, in 1940, would collect things from the park and built a wall. We call it the Dunsmore Sanatorium. That's what it's called now, but it's a thin wall. I actually had to research it. I thought it was so cool because it looks so weird. They have all these weird designs.
Things in it.
Yeah, and they made it, and that was out of love. That took 10 years. They stopped it in 1950 when they finally completed it. That took years, and it took love. It took love, and that's what makes it, this park, this community, so beautiful. It takes time and love, and it was natural. It was fine. It was something that we had. And I feel like if we were to build this tower, it makes it less natural and less beautiful than it is because it's fake. And it's just putting a Post-it note saying, hey, this is not a tree, but we're going to say it's a tree. I don't think it would fool the school kids either. With that, I'm done.
All right. Thank you very much. Jonathan Sherman? Sherbet?
Yes, Jonathan Sherman.
Okay, thank you, sir.
Thanks for letting me speak and listening. I know you guys are probably tired. So I'm not. My thoughts aren't totally organized because I actually just found out about this at about 4:45, and I work in Burbank, and I raced right over here. That's part of my concern about this. I live on 3rd Avenue between Lauderdale and Boston, very close to the park. I've got 2 young boys, age just about 10 and 6, who go to Dunsmore. And so I'm concerned about, and I can speak about the health issues, I'm concerned about the health issues with this tower, potentially, because it could go well beyond, the 200, 250 feet that the FCC says. Mainly, really, I just think there's a lot of information here to give you guys pause to make a decision on this. If it's not going to be no, I'd like you guys to not pass it. But if you don't feel like you can do that, I just feel like I'm a perfect example. I called one of my friends who also has 2 boys who goes to Dunsmore. He didn't know anything about this. I never got a notice about this. Now, maybe this was not legally. I was not close enough to the school or the park to get the notice. But I can assure you, if I knew about this even a week ago, I'd have 200 people here. And so I do think part of, I believe in terms of, democracy and what your guys' responsibility is at least to hear what the constituents and what the community has to say. And so this is a pretty small group of people who have come out, but I'm a perfect example of, if I hadn't gotten an email from my brother about this, I wouldn't even be here. I wouldn't even have known about it, and I would have one day just woken up to an article or walked to the park and see this in construction. And I just feel like it's very important, at very least, I understand there may be some restrictions as to what you guys can base your decision on. I actually think there's been quite a lot of information, not just health related, as it speaks to maybe the type of trees that are there or the usage, the way it was categorized by AT&T. I think that alone maybe should give some pause for there to be more review. But I think at the very least, I think it's important that the community at large, the community in that area, knows about this. And you get to hear from them. I think it's also interesting that thus far there's not been everything has been opposing this. I want to be clear that I oppose it. There hasn't been anybody yet who's come up from the side supporting the tower. And I suspect that, let's say you propose another meeting for this or hearing for this in a couple of weeks, that there would be a huge outpouring, standing room only here. And I do think that that's something that's really important. That to me, I mean, I have very strong feelings about it, obviously personally, with my children and that park. But I think it's really important that you would hear from a larger group of people. So I kind of would like you guys to keep that in mind. I also want to ask a question about the health issues, about what you guys are not allowed to do. I don't know the name of the board, but there was a cell tower that I think it was about 9 months ago, 6 or 9 months ago, that was proposed to go up at the sheriff's station on Briggs. That had several hearings, was overturned. There was a couple hundred people who went to that final meeting. There was petitions. The health concerns was a major part of what everybody was speaking about. The board ended up not allowing it to go through. I don't remember. I was at a couple of those meetings. I don't recall, and maybe they have different rules as what you guys do, but they never mentioned that they couldn't make a decision based on some of these concerns. I also think, I don't know truly the board members what they believed personally, if they felt like they wanted to approve that cell tower or not, but I think at the end of the day, they just couldn't turn away from this outpouring from the people. I think they realized, well, everybody in this community, they really don't want this cell tower here on Briggs. It was undeniable, and I think that's what ended up doing. It was great. I felt like it was democracy at work. It was a great moment, I felt. So, again, to repeat that theme, I think that that's something to consider. So even if you can't consider it based on specifically the health concerns, at least just the community outpouring, because I think that is something that you guys, should be listening to, how the people feel about it. So that's my main thing. I just hope that you guys won't approve it. I think there's a lot to kind of consider, and I just have a concern about people knowing about this. If I could just ask a question, was the school board and was Dunsmore Elementary School, were they alerted to this? Were they given notices about this as well? Do we know?
I would guess that if they are within the 250
It's 500.
Oh, it's 500 feet,
radius.
noticing that they would have been.
Okay.
You can check the radius map, and there's a list of individuals who are on it. If you feel that that was a problem, I think that's something that could be brought up.
Yeah, so I guess if I'll say, while I still have a little bit of time, I think that if I can make a point is that, I'm just glad to be here that I was alerted to it. But I so easily could not have known about this, and I just feel like there's so many, I'll wrap up. I know there's a lot of people who would be here if they knew about it, so I think if there could be, that should be something that should be considered by you guys, please.
Thank you, Mr. Sherman.
Thank you very much, appreciate it.
Antonella Wilby.
So this is a Wilby family affair.
Yeah.
500 feet.
Hello, my name is Antonella Wilby. I am a computer scientist studying for my PhD, and I would like to also register my opposition to this cell tower. So I attended Dunsmore and grew up walking through the park to go to school, and also Clark Magnet High School. I'd also like to, add to the votes for sliding cardboard birthday parties. I probably had 5 or 6 of them. And also, in the report saying that this would not impact recreational use, I'd like to also add to the other voices which are saying it would. Just as a personal example, I've had a knee injury for many years, and when I'm home at my parents' house, if I want to go running, I don't like running on the pavement, and that is the only continuous grassy area I can run on in circles around that baseball diamond. And based on the site drawings, that fence would basically take up that entire area. So you'd have to be running down the hill, which very quickly is just a bunch of boulders and stuff. There's really no running area. So those are some personal reasons. I'd also like to ask about the environmental report, because I don't know if anyone here is familiar with antenna design, but I do have a little bit of background in that. And I'm really concerned that AT&T would not share that information. For example, what is the transmit power at that source? Because a cell tower, to reach a large coverage area, has to transmit at a very, very high wattage at the source. And that source is right at that baseball field. In addition, the beam pattern for the antenna, unfortunately, I just found out about this meeting very early on, so I don't have any evidence to give to you. But if you do look up antenna design, that beam pattern will be blasting straight down onto where the kids are playing on the baseball field. So regardless of any health effects that you may or may not be able to take into account, basically anyone in that area, the schools, the neighbors, they will be subject to an incredibly high power microwave radiation. And it's very concerning to me that this has not been disclosed in any of the impact surveys. I would personally like to see what is that power, what is the frequency range, what is the attenuation at a certain distance away from the tower. If I'm 200 feet away from it, which is maybe my parents' house is maybe 350 feet away, what level of power and the radiation will I be experiencing in my home? And I would like to see AT&T provide that information. So with that, that's about all I have to say, but if I may cede my time to my father, Kevin Wilby.
You can.
I can? Okay.
I'll hustle. Still Kevin Wilby, still live at 4811 Cloudsdale. And thank you very much again. Just what I didn't get to. This is a lease, and someone's getting money from it. And we should have more transparency. What are we talking about? In 2013, Microsoft paid $400 million for 5 years to use a Surface tablet on the sidelines of the NFL games. And is this the sort of money we're talking about, $80 million a year? Because it would be good for everybody in the neighborhood to know what we're selling ourselves out for. Because if it's chump change, that makes us kind of cheap. And in Moscow, one thing they did, they put up what they called mosquito screens to harden the embassy against the microwaves. Is AT&T willing to foot the bill to harden Clark and Dunsmore and St. James from these microwaves? It's all money, right? So I think I did that quickly. The only one other thing I had to say on your technical drawing, there's a 74-foot high pole that comes out of the industrial site that doesn't show up in the lovely renditions of the monopine. It's, when you give the pictures with it inserted, there's not the pole that's designed to somehow bring power over. And either, I don't know what the draftsman was doing, or not sure what that 74-foot, they got it down to 0 inches, so they know it's there. I'm not sure what it does and why it doesn't show up on your renditions. And all the other stuff, the birthday parties, the sliding, I thank everybody for doing such a good job during that spirit. It's on your middle drawing
sheet?
right there. And
here?
yeah,
A1?
Now I was working off the computer screen. Can I go around and show you?
No, sir.
No, sir. Okay, I won't. But check right.
I'm looking at A1.
Okay. Might be on this one. Is there one here?
Yeah, it's the same thing. A1 there. That's right, I drink it.
Okay. Proposed AT&T overhead power and telco service drops approximately 74 feet 0 inches. That's an accurate approximation.
Okay.
Thank you.
Thank you very much.
Right there. Thank you, Wilby's. Eric Sherman.
Hi, I'm Eric Sherman. Thank you for letting me speak. My brother Jonathan Sherman spoke before. I was just sitting down to a nice quiet dinner when he gave me a call and said, hey, if you could come to this, it'd be great. So I was not prepared for this at all. We just found out, and as Jonathan said just before, I think it'd be really great if one thing that could come out of tonight is to decide that we do need more time before a decision is made and that more people are allowed to find out about this and share their opinions. I've been a resident of the area for about 15 years. I own a post-production facility in Burbank with a couple of facilities there, and I live in Lake Center, like I said. We were successful in stopping the tower from being built on Briggs last year, which was a great thing for us. We probably would have had to move out and not been able to have my son continue going to Mountain Avenue Elementary School if they had built it. My son was born with cancer, and sorry, it's hard. Remember, I talk about that. It was a hard fight for him. He's a survivor, born with tumors in his eyes, and he's made it through. But he's susceptible, and there was no way we could have him go to a school where he'd be hit with radiation from a cell phone tower. Both my nephews go to Dunsmore, and my son, we love to play at the park there all the time. He plays baseball, and we would not be able to go anymore if they build this tower, and that'd be a terrible thing because the park is a really nice park. So I don't think I need to belabor the point. When you guys want to get out of here, I just wanted to stand up and say that I really strongly oppose them putting up this tower in this location. Thank you.
Thank you. Thank you. I believe I only have one left. If there's somebody who wanted to speak and I don't have their card, you may turn it in at the last minute. Jesse Lowe's. There's a whole paragraph here, but I barely can read it, so I don't even know if Jessie Lowe's is opposed. So.
Oh, she had to leave. She's the gal that she had to go speak with her mother.
Okay.
She had some emergency.
Opposed or for it?
She didn't indicate opposed or for.
Opposed to it. She said she goes out and sits there every day.
Okay.
For an hour and a half.
All right. Okay. Thank you. All right. Maybe I do. Kurt, I'm sorry if I'm. Kurt Friedenberger. Sorry, Kurt.
Tell him your name.
Kurt. Hi, Kurt.
Do you want this?
Oh.
Kurt is a kid who grew up in the area and has gone to Dunsmore his whole life, basically, as a Boy Scout. And he played there and he had parties there. And
This doesn't want to. It's that too, and that tree is very tall, and it's not like the trees in the neighborhood. And can we give our time to Rola?
To who?
To Rola, the lady over here.
The dilemma is this, is that if you wanted to, you should have written it on there.
Oh.
And there was an individual who did, and we allowed that to happen. But asking to do that at this time just prolongs.
Okay.
Two other people at the time.
And they had, we did. So thank you very much. I did. And it's at the discretion of the chair. And I don't think we're going to get any more information that we need at this time outside of what we have been given to read. So thank you very much. We really wanted to hear from you. We now have time for a 5-minute rebuttal from the applicant, Jerry Ambrose.
Thank you again, Commissioners. I'll address the issues that I can address, and I won't go in any particular order, just written them all down. First comment is, from a big picture standpoint, the intent of this project is to be a community benefit. A vast majority of people, rely on these little devices, whether you like them or not. Most Americans, most people have these, and they do everything for 911 calls, business use, personal use, all kinds of uses. They can. It's unimaginable what you can do with them now and what you can do in the future. And in order for these devices to work, you have to have the infrastructure close by to where you are. Currently, about 60% of homes use only wireless devices, cord cutters, and that number is spiking. So most of the projects that we do nowadays are in residential areas. We're on a lot of churches, schools, parks, because that's where the demand is coming. In order to service that demand, the infrastructure, the antennas, the equipment has to be close to where, just to where that demand is. There was a lot of comments about the environmental review and about CEQA. Typically, they are exempted as a Class 3 exemption. I think that was mentioned earlier. The issue about the utility pole, there is an existing utility pole at the southeast corner of the park. We intend to connect to that pole, but the service would go underground and be routed to the equipment. We wouldn't intend to put another utility pole next to where the cell tower would go. And in terms of routing where the route of that utility line goes, we're flexible on wherever it needs to go to get to the point it can go around. It doesn't have to go specifically where it is on the plans. There was an issue about liability. It's a city lease. It's a document that we can't edit or can't comment on. It's already been prepared by the city attorney. We just have to accept it as is. So I assume the city has accounted for anything that they need to within their lease document. In terms of, there was a question about the report and about the operation of the facility. We're happy to prepare an EMF or an RF report if that's something that the city wanted. Some cities require that just as a condition of approval. Give us a report that shows how it operates and show that it's in compliance with FCC standards. Again, we're happy to do that if that's what the city desires. And I think there was a lot of comments, of course, about the location in the park. As I mentioned earlier, that location was something that the city directed us towards. So it met our technical requirements, so we essentially followed their lead in where they asked us to go. So that's what we've done. Also, it wasn't mentioned, but we originally had a fence around the equipment. Now there's a slump stone decorative wall with a chain link, we call it chain link lid, that's inset down into the wall so that no one can get into the facility. And if a ball goes on there or something, it can be taken out. Again, that's all I had in terms of the things that I can discuss. So, any other questions? I'm here to answer.
Thank you very much.
I have some questions.
Any questions for Mr. Ambrose?
I have a question for you. So how does the process work? You contact the city and the city goes 1, 2, 3, 4 is available, go look at it? Is that how it works?
How it worked here is I contacted the Parks Department with the city, and I said, are you interested in having AT&T as a tenant? on Dunsmore Park? And they said, yeah, sure, because again, they have a template. They've already had lots of cell site leases with the city. And so I met with Coco, the director, with our team, and we talked about different options, and he directed us to that particular location. He was there. We walked it with him. We sent the plans to him. They approved the plans, and then we submitted to the city for the conditional use.
So, Mr. Rambers, I have another question from you. The Cloud Avenue water tank location.
Yes.
That you eventually withdrew your applications for CUP?
Correct.
Because there was community opposition.
It wasn't just community opposition. The Board of Supervisors they were going to make sure that it didn't go forward.
Can you tell me why, what was the opposition, on what grounds?
Similar concerns. There were most of it had to do with the EMF concerns.
The EMF concerns.
Correct.
And the Board of Supervisors heeded to that concern.
Not through me directly, through other folks at AT&T who have governmental relations, public affairs, those folks. So I was just directed.
It's like picking up the phone and say, hey, don't do it in my backyard. Is that how it worked?
I don't know. Again, that's people that were above me, but I was directed to withdraw the applications. That's what we did.
I see.
And this is the alternative to that.
So if I may, I don't mean to labor the process, but there was an assertion made about 2,000 feet being the safe zone as far as emission is concerned, the radio frequency. Is that something technically that you're aware of, or no?
I am not an engineer, an RF engineer. I don't know anything about the operational characteristics. I deal with the land use and the permitting. And obviously, the AT&T complies with FCC standards.
Sure.
They have thousands and thousands of cell sites everywhere. Sure. They've had them for 20 years. All the other carriers have thousands and thousands as well. So I couldn't speak to the specifics of that, but as I said, if you wanted AT&T to prepare a report and show you all that data, we'd be happy to do that.
And we would be asking, that was the next thing that I was going to ask you. But let me, before I get to a little bit more juicier questions, let me ask you this. You have, you heard my sentiment about the alternatives that you had chosen.
Correct.
But my question from you is this, that did you ever look at other cell site locations that you could co-tenant with them?
Yes, there are none in this particular area. Right now, AT&T is just about to build a site on Orange Avenue. I think it's 2723 Orange in La Crescenta. T-Mobile has an existing tower, and AT&T is just about to install their stuff on that tower.
Okay,
we try to pick the path of least resistance because we want to get to the point where the site's on air.
We can see why, yeah.
We always try to do that. But again, when you're trying to service residential areas, the alternatives are very limited, and you have some folks that are against the projects. So it's trying to weigh the demand for the service, because again, we all have these devices. That infrastructure has to be there. Earthquake comes or there's a fire or something, everybody goes to their cell phone, and they won't work if there's too much demand on the cell towers that are there now. They won't work. So then it's, well, God, I wish you had a cell tower there because we couldn't call our family, couldn't call anybody. So balancing act.
So let me finish up by saying that you mentioned that this is a community benefit, and I'm sure there are a lot of people that believe that. What happens when the community doesn't want that benefit? What do you do then? They don't want the benefit that you're giving to them. What are you going to do?
That's sort of a subjective question. I would just say, from a practical standpoint, there are a few folks here that don't want it, but I don't. I didn't go out and look for thousands of AT&T customers to come in and say they want it. So that's a hard question to answer because you have some representation from the community, but you don't have all of the community. There are a lot of AT&T customers in the area.
How many would
and
you say?
There are legal remedies as well. Honestly, there are legal remedies because the city is very limited in what preaching. As you know this, the Telecom Act came into effect in 1990. It's been 20 years.
That's correct.
So we've been through this for a lot. So they often, not often, but sometimes they have to go through a legal challenge to provide that infrastructure to fill that gap in the service because they have customers and they have demand and they have.
How many customers in that area for AT&T?
I don't know exactly.
But you can get that information.
I can get that
to
information.
staff.
Sure, I can get that.
Okay. Thank you, Madam Chair.
All right. Any other commissioners with a question? I have one. I am looking at your site plan here, and I am wondering how you will access this site here to build this, as well as to maintain it. There are no roads or accesses shown.
Right. The construction phase is the initial phase, and the discussion with the Parks Department, it was to drive from Dunsmore around the fields to build it. After it's built, they only need pedestrian access to go in there and do maintenance on it. They don't need any big trucks or anything, because once it's in, it's in. If for some reason in the future they had to make a change on the tower and they needed some kind of a crane or something to come in, they would go that route, obviously coordinated through the Parks Department, for a temporary use of that route.
And so has this plan already been seen by the Parks Department and given a blessing?
Yeah, they've approved that plan for us to submit into zoning. They ultimately approve there's a final construction drawings that are more detailed, that they'll have a chance to approve those as well. And I assume they'll have an access route requirement in the lease.
Typically, Planning Commission meetings are posted. Where was the posting for this meeting?
It was facing. I haven't personally gone out there and seen it. I think it's facing Dunsmore. I sent a photo to.
It's hidden behind the tree, personally.
Let me see where it was posted.
Yeah, it's by the south end, by the stairs.
Thank you. Thank you.
Yeah, thank you.
That concludes the public portion of this meeting. I am going to close the public meeting, and we will, unless you all would like to bring somebody up for further.
No,
Okay.
please don't.
Thank you.
But
All
I do
right.
have a question for staff.
Please, Commissioner,
May I?
proceed.
So, explain something to me. We have a wireless facilities engineer in the city, right? Has he reviewed this application? I forget the name of the gentleman, but I did meet him once.
It's Gordon Allen.
There you go. Okay. Has he reviewed this?
Arnold.
Arnold. Has he
I always
reviewed
get it
this?
confused. He has, and he submitted his comments.
And
And
he had no
recommended approval.
issues with the.
Correct.
And as far as the.
Mr. Astorian, I
coverage,
think
this
he just substantiates that there is a cell void there and that this would serve that. He makes no other determinations. Am I correct?
Correct.
Thank you.
Are there any other cell towers in the area? I heard the gentleman said no. Do we know if there are any other cell towers in the area? How can we find out, Mr. Cross?
We could, outside of going out and looking, we can take a look at whatever recent applications have been filed with the planning department and
If
determine
Arnold
what
was
those
here,
were.
he would have been able to tell me if there are any other cell towers in the area and whether or not this could be piggybacked on it or co-tenant. And I know you've looked at AT&T sites and the T-Mobile and what have you. So that's kind of information that we need when we are deciding this stuff. In fact, last time we had him here, right?
Yes,
Ms.
we
Landrigan?
did, at the other part.
Right. Okay, thank you. Those are the questions.
Any further questions of staff? No questions. Commissioners' discussion? Or motion and discussion, whatever order you wish?
We can deliberate amongst ourselves, but I will tell you some of the issues that I have. I know that by the federal law, we cannot take into account the issue of the health.
Environment.
And the environmental, I'm sorry. And so I'm aware of that. But I do have a problem, and I did have the same problem with another time, and they came back with a much better alternative than they had the first time. When I look at the alternative, the 8 alternatives that they have, in my opinion, as I have voiced it prior to Mr. Ambrose at the beginning of the hearing, in my opinion, the last 4 alternatives are really no alternatives. I mean, there's no. I mean, it's as if it's there just to make up a list. And the first 3 or 4, 2 or 3 of them are really no alternatives, because if somebody is telling you, no, we're not interested in it, practically you can't consider it as an alternative. The alternative is when it provides a viable chance of achieving the goal, in my opinion, at least in my training. So having said that, I am not convinced that they have looked at all the alternatives and whether or not they will be able to get a better place. Now, the dilemma that I have with what I just explained is the following. You have Kevin sitting there and telling me that the safe space or the safe distance is about 2,000 feet. And they have to propagate that area. Anything within 2,000 feet of this is not going to be safe for any one of you that believe that there are some health and environmental issues. So I don't know how I will mitigate that, and I don't know how I will consolidate that, but that's my thinking, Madam Chair.
Thank you, Commissioner. Mr. Manoukian?
Well, Madam Chairperson, I am of the mind to reject the application because the antenna is not compatible with the current uses of the park. As an AYSO coach, I have coached many teams on the park, and I know that area that they're talking about, and I've seen how much usage that area gets. And putting this tower there would impede the otherwise normal use of the park. That's the basis of my decision. And as far as the rest of it is concerned, everybody needs to be aware. You may get what you want, but beware, because somebody was telling me about being a teacher at a if an emergency happens and if we do not have an integrated and comprehensive network of cell towers, and if things go sideways, the same people who speak against the comprehensive and integrated network of cell towers have to answer for it. So with that in mind, that doesn't change my opinion, because I do believe it's a large piece of what do you call it? Area that we're talking about. So they're going to be able to find something. But as far as this particular application is concerned, I'm afraid I can't go along with it.
You were referring to Rain Gibney. Did I get that right?
You did.
All right.
And my cell phone works just fine.
That's great.
Where I live and where I work, both within 500 feet of this proposal.
That's fine.
Commissioner Shabazz.
After hearing everyone and kind of assessing this, I kind of have to agree with my colleagues that maybe an alternative location might be a better option for the cell tower. I'm not familiar with the park, so I don't use the park, but I see that the residents around it and Commissioner Manoukian are telling me that there are going to be some effects on the actual physical appearance of the park. So that means we are going to be taking away from our open space, and I don't think that's something that we want to do. We want to encourage for more open space. So with that said, I would encourage maybe to look further for a better solution, to see if we can come up with something better, a better place for a cell tower, maybe not in the middle of a residential area.
Well, I would have to concur. I think siting a cell tower adjacent to a very active recreation area is blatantly in, I think, opposition to what the North Glendale vision plan has stated, and I was party to that. Many of the other cell towers have had parking lots that buffer them. There's nothing of that sort, and we're taking, it already breaks my heart that we take more and more open space away from our citizens in Glendale, and this is one of those that I really think would be a taking in my mind. So I I do think there may be a fine line between health and environmental. I appreciate all of the research and materials you've given. I think that a very proactive activity would be to write our senators and to tell them they need to do the right thing. We try that, but I mean, it doesn't hurt to try. I mean, all of you all have been here, and to write your Congressman, Adam Schiff, and to let them know that, you know, being current on environmental studies is really important, and we've had plenty of studies now that really need to be incorporated. I think I will ask for a motion from one of the commissioners here.
I will move to deny the application for conditional use permit for the tower as proposed by the name of the company, Yukon, right? Because there is no, I do not have an alternative motion here. The only motion that I have is for approval.
Planning Commission members, if I can suggest that we continue the hearing to come back with findings to deny the application.
Certainly, and you heard at least two that had to do with the compatibility and the facilities or the alternative facilities.
Correct.
And I think those are the basis that we can deny it as opposed to anything else.
Yes.
So yes, then I do move to continue
without further notice
the proceedings without further notice to date certain. That would be
next time.
Next week we're here.
Next time. 2 weeks.
Next time, that's 2 weeks. Is that fast enough? I mean, is that too fast, maybe?
July 20th. July 20th.
With a motion that includes the findings for us to deny this application for the CUP.
Yeah.
Not the CUP, Planning Commission members, but the wireless telecommunications facilities permit.
Oh,
Yeah,
okay.
the permit, yeah.
All right, the permit.
Okay.
So we need a second.
Second.
May I have roll call, please?
Planning Commissioners Astorian.
Yes.
Manukian.
Aye.
Shabazian.
Yes.
Chairperson Landrigan.
Aye. Thank you. The action has been for the commission to have staff come back with a motion that includes all of the findings that we stated to deny the application. And that will be back at our next meeting. It's without further hearing, which means there will be no more testimony taken, so that it will be to finalize our action. Thank you very much.
But you're more than welcome to attend the meeting again.
To chair our
July 20th.
July
20th.
All right. So thank you all. Thank you very much for your public comment. Item number 8 is Community Development Department updates. Do we have any?
No.
None. Comments from the commissioners? Anything the commissioners would like to?
No. I do, and it's rather important.
Commissioner Astorian.
So, for the first time ever in the city of Glendale, Glendale Association of Realtors will be hosting an event, a fundraiser for the Wounded Warrior Project.
Great.
We're all very familiar with the name. It'll be on June 30th. I don't know if the camera can zoom.
Zoom camera, zoom.
Doesn't. It'll be on June 30th. And it will be held at Hollywood Productions on Broadway. And the tickets are for $20. And I promise anybody that wants to attend a very good time.
Thank you, Commissioner Astorian. Seeing no other business,
Move adjourn.
we are adjourned.
So done.